further specialized techniques.
We also heard a lot from Dr. Rubino about brain symmetry and the size and the comparison.
Sure.
Could you just talk about brain symmetry, what that is?
Sure. Well, it's just basically looking or comparing one side of the brain to the other. And so I'll tell you with regard to this imaging. Now, just to give you a little background, so I probably look at about 700 to 1,000 brains a year, and I probably looked easily over 10,000 brains in my career of all different ages. Looking at a brain with my eyes and my hands is very similar to how we look at a brain radiographically. So when a person does a CT or an MRI, they're taking slices from front to the back or top to bottom or side to side through the brain because they can't do it physically on the person, right? Whereas I can physically examine a brain, and I cut the brain the exact same way that a CAT scan or MRI does. So we're looking at the same thing. Our appreciation for brain anatomy is the same. As a matter of fact, an MRI hopes to get to the, one day to the clarity, if you will, or the resolution that I have looking at it with my eyes. That being said, the problem with looking at symmetry on the PowerPoint is that you're looking at one slice. So if I can just give you an example of comparing, especially the ventricles, because the ventricles are hollow structures within the brain. And if you can imagine, let's say, two footballs placed here on the table side by side. We know that a football is conical in shape, right? So if you look at the front of the football, it's going to be smaller. If I put a slice through both footballs, it's going to look smaller. As I move back to the middle of the football, if I put a slice, they're both going to look bigger, right? And that's assuming that I'm making that slice perfectly level with both footballs at the same exact level on the horizontal plane. But let's say if I just angle my knife just a little bit, where I get a little more of the anterior portion on the one on the left and a little more of the middle portion of the one on the right. If I look at that, one is going to look smaller than the other. It doesn't mean that there's true asymmetry. It just means the level at which I'm looking at is not really level, okay? So you really have to get a volumetric analysis of the entire ventricle and compare one side to the other to truly say whether or not one ventricle is larger than the other. Looking at one single slice can't do it. When you look at the slice that he showed there, you can clearly show that the hemispheres were on different levels. Specifically by looking at the inferior horns of the lateral ventricles, you can tell that they were not level. So to take a measurement of the ventricular size at that particular point was invalid. So it's hard to compare those two.
Thank you. I would ask if Dr. Coyne could step down
Yes.
so I could ask him questions about the imaging.
Okay, sure.
If we could have the microphone moved over just so we can hear. Dr. Coyne, I want to go through the PowerPoint that Dr. Rubino prepared.
Sure.
And are these the scans that you also reviewed prior to coming here today?
Yes, yeah.
All right, so let's start with this scan. What do you note about this first scan?
This is a horizontal section through the brain. You're looking here at the ventricles, which look more white, if you will. And what he is claiming that there is asymmetry between these two structures. But by looking at the posterior horns here, you can see the length difference between the two. That's because this is not a complete level section through the brain. You're looking at a different level from the right compared to the left, so you're not comparing the same. So you can't make an accurate measurement here from one side to the other. You're going to get different measurements because of that. So you have to look at the volume of the entirety of the ventricle.
And so based on that, do you believe there's anything significant?
No, and I'll tell you further why, right? So if you had asymmetry in the ventricles, or let's say, for instance, he also described that there was an abnormality in the size of the ventricles, that they were actually more narrow or smaller. They're not. This is actually appropriate in size. And he suggested that because of that, there's probably due to increased intracranial pressure. But that doesn't happen in isolation. Increased intracranial pressure is going to cause fluid from the ventricles as well as fluid from the vascular space to spill out into the actual brain tissue, and that's going to cause abnormalities in the CSF pattern as well as it's going to cause hyperintensities around vessels. You see none of that here in this actual scan whatsoever. Not to mention, increased intracranial pressure is going to push the brain parenchyma out. The brain is trapped in the skull. It has nowhere to go. So if you increase pressure inside that skull, the brain is going to be pushed outward and downward. And you see no evidence of that at all here. You don't see any evidence. You see the normal sulsation right here or the normal folds of the brain. You have no evidence of that increased intracranial pressure. More importantly, like I said, there's no overt evidence of abnormality in ventricle size, and that matches what the radiologist saw on both the CAT scan and the MRI.
And what was the radiologist's opinion on the MRI that we're
The
looking at?
MRI was that there was no difference in the size of the ventricles, and that's important too. I know he had mentioned that normally a person wouldn't make comment of that on an acute CT. They very well would make comment of that, because if you see asymmetry on a CAT scan, what it suggests is that there's perhaps some underlying mass process that's pushing or changing the size of that ventricle that needs further evaluation. So a radiologist would certainly make note of that, and a doctor would certainly have to follow up with that.
Now, he also mentioned about the space, made some issue about the space between the skull and the brain. Can you
talked
describe
about, yeah,
that?
sure. So this is a little bit higher up, so I can't really see the temporal lobes here, but you can certainly look at, so here's the frontal lobes of the brain. The orbital frontal lobes are the part of the frontal lobes that curve underneath. And normally when you're comparing the width of the sulci of the orbital frontal lobes, they're going to be a little bit wider than the normal sulci that you're going to see on the lateral frontal lobes, as well as the sulci that you're going to see moving posteriorly to the temporal lobes. So what he's describing here is just the normal spaces between the individual gyri of the brain. And how do I know that? Because the cortical, so if there was atrophy, you would have loss of brain substance. You would have loss of gray matter, and you would have loss of white matter. The cortical size is of normal thickness. There's no loss of cortical size. More importantly, the distance here is all normal. So there's no loss of white matter underneath here. You don't have atrophy in the absence of loss of brain substance. Brain substance is absolutely normal. More importantly, this is all, the white matter from here travels down through the center of the brain into our spinal cord. If you lose substance, you get an increase in size in the ventricles. That's well known, and that's not seen here. So I see no evidence of atrophy at all on this brain. More importantly, when you look at the temporal lobe, he describes changes in the amygdala and the hippocampus. There is no atrophy whatsoever that I can see at all looking at this. More importantly, any atrophy, if there was, certainly I don't think wouldn't have any behavioral readout.
We could go to the next slide, please. What are we looking at here? Is this just more of him trying to say?
This is just, yeah, him using whatever program he has on his computer based on a scale that it has to measure the millimeter size or width of these ventricles. But like I said, look at the differences here between the posterior horns. It shows you that this is not on the same level, so it's slightly off. So you're getting more of an oblique or tangential cut through here, because again, like I said, you're dependent upon a person laying in the MRI tube. Nothing is going to be 100% level. So you really have to look at the entirety of the volume of the ventricle. So look at the volume of the ventricles at multiple levels, not just a single level, and take a measurement and then make an assessment of that. But like I said, if you did have alterations in this, then where is the alterations in the rest of the brain? We don't see that either.
And for the record, you were just referring to slide 3 of Dr. Rubino's PowerPoint. We're going to go to slide 4. What do we see here, doctor?
This is moving more anterior. This is moving more up towards the top here. Again, you're just looking at the white matter, but what we're looking at here, so this would be white matter tracts here. And again, he's talking about these spaces that you see here between the frontal lobe. Again, you could tell that they're at different levels, right? Look at the sulsations different, but more importantly, the white matter pattern is normal. The width of the white matter, I don't see any evidence of atrophy there. More importantly, if you have trauma, let's say we're saying this is due to brain trauma. All right, this is due to a deceleration, acceleration type injury, or direct brain trauma where a person has an impact and then the brain moves both linearly, slamming into the front of the skull and the bottom of the skull, and then rotates about its center axis. And that causes a shear strain to the brain. Number one, it deforms the brain substance. And because the gray matter and the white matter are of different densities, they move at different speeds relative to each other, creating shear strain stress that affects not only the gray matter itself directly, much like if I punch myself in the arm, I'm going to get a bruise. And maybe if I don't get a big bruise, I'll get a little redness or definitely a change. Well, you would see that long term on the brain if you had a significant brain trauma. You would see hyperintensities, calcifications around small vessels. You may even see atrophy. More importantly, you would see an abnormality in the white matter pattern due to that trauma. Or you would see alterations at interface between gray matter and white matter, in particular along the long tracts that cross the hemispheres and go downward into the spinal cord and brainstem. And we don't see any of those changes here.
We can go to the next slide, which is slide number 5. What do you see here, doctor?
This is just, again, another example looking at the ventricles and trying to make an estimate that there are abnormalities in ventricular size. Also, arbitrarily choosing one point versus another point. Again, you can't make an assessment of ventricular symmetry by doing that.
We'll go on to the next slide, which is slide 6. What do you see in this slide, Dr.
Sure, now we're looking more towards the base of the brain. Here's the temporal lobes right here. You're looking into what would be, here's the midbrain right here. And it was probably more pons, actually, midbrain to pons, cerebellum. More importantly, when I look at trauma in a brain of someone that's had significant impact trauma, I'm going to see white matter pathology, very commonly in the cerebellar peduncular white matter that comes from the brain and brainstem into the cerebellum. I don't see any changes of that here, but more importantly, I don't see any atrophy of the parahippocampal region or occipital-temporal region, which houses the amygdala and the hippocampus. So no, I see no evidence of atrophy here at all.
All right, so if we could go on to slide number 7. Doctor, what do we see here? Is this just a further?
Yes, it's just another look at, another level of that same region.
And again, everything appears normal on that slide?
Yeah.
All right, what about slide number 8?
This is actually a great just image looking again. This is now the orbital or the frontal portion of the brain here. And again, this is normal distance or normal spacing between these gyri that you see in this part of the brain. More importantly, as I said, you do not see the atrophy that I normally expect to see when it comes to trauma. The asymmetries that you see here in DTI pattern are quite normal in individuals because there's a functional, there's a functional hemispheric differences in white matter pathways, right? So there are laterality in functions within our brain because of our experiences, things we learn to do throughout our life. There's going to be differences in density of myelination and white matter in our brain, which will present as asymmetry. This pattern here is not something that I would be consistent with traumatic brain injury.
Moving on to the last slide, which is slide 9. Doctor, is this just another?
Looking a little further backwards, yep.
All right, and again, no abnormalities, nothing here that suggests any kind of brain injury.
Agreed.
Okay, thank you. You can step back up. So, Doctor, based on your review of these scans, would you have ordered anything further if the defendant was your patient?
As a radiologist, or just as a physician for that matter, I would have looked at these instead of normal brain. If I was writing up a brain pathology report based upon this, I would call this a structurally normal adult brain, and I wouldn't be concerned about anything significant to chase after.
Now, another thing Dr. Rubino testified was about lateral asymmetry on the 2023 CT scan that was part of the medical records. Did you have the chance to review that?
Well, yeah, I did see those CAT scans. I know what he's referring to, and he's referring to basically the same asymmetry that we pointed to on the screen there. That is an asymmetry in the lateral ventricles, which were not noticed by the radiologist, and certainly I didn't notice any changes either.
So again, same assessment from 2023 as you've made now. There's no evidence of asymmetry.
Yes, I mean, our brain is not 100% symmetrical. And when you look at one side or the other, you're going to see differences in just the general morphology that you can pick out with your eye. But again, it's really the total volume that matters. And in this case, that wasn't done. It's inappropriate to do one single measurement like that and then generalize to the asymmetry of a ventricle.
Now, the other thing he talked about was the difference in size of ventricles. Could you just explain whether that's significant or not?
So I know that there is certainly a wealth of literature out there looking at ventricular asymmetry and its involvement in psychiatric illness. The problem is that, still to this day, whether you have schizophrenia, bipolar disorder, or other well-known psychiatric illnesses, there isn't a neuroanatomical substrate that allows one to diagnose an underlying psychiatric condition. And so we can try to generalize by saying, well, this brain region is involved, we know that this brain region is involved in these types of behaviors, so therefore if we see a change here, we would expect to have this kind of behavioral abnormality. But That doesn't necessarily always hold true. There's certainly a lot of compensatory changes from one side of the brain to the other. And again, like I said, there's different functional reserves from one person to the next.
And again, based on the CT scans and SMRI, you saw no evidence of any sort of...
I did not see any evidence, and more importantly in this, I didn't see any limbic system atrophy.
Did you see any damage to the amygdala or the hippocampus?
I did not.
Now, the other thing that Dr. Rubino testified...
Just to add one thing, not only just the hippocampus and the amygdala, but the nerve fiber tracts that are important and integrate with that, the fimbria, the fornix, as well as the surrounding white matter.
And those were all normal.
Yep.
Now, we talked about the MoCA test, and I believe it's a one-page assessment. How would you describe the MoCA test?
Well, clearly my patients wouldn't respond well to that because they have no pulse. But what I would say, that's certainly something that someone uses as a upfront, quick assessment. It's certainly not the, I wouldn't base my diagnostic or my diagnoses, on that. It would clue me into what I should do further. In other words, if I'm doing an initial assessment of a patient and I see, hey, there may be a problem here with short-term memory or concentration, then I would do additional neuropsychological testing to really hone in on those abnormalities. A snapshot is a bad thing to make any opinions on, especially in this case because of the setting. We already discussed, and he even alluded to that when he performed the test, that there were guards overlooking Mr. Wilson, that he appeared nervous or anxious. That would certainly, cause an upregulation in your sympathetic nervous system or the activity of our sympathetic nervous system, which antagonizes normal short-term memory. And we can think all of us, if we were taking a test and we had someone looking over our shoulder, we would be much more anxious, and our ability to think through that test would be more difficult. And even you could talk to law enforcement officers who would tell you that, in situations of stress, when your heart rate goes up and it reaches a certain level, your ability to concentrate and think is decreased. So the same thing in this scenario. It's hard to really draw conclusions about one person's short-term memory from a single assessment. Furthermore, same thing with the cranial nerve assessments if a person is shackled or in a setting where they're not able to truly really give a true clinical examination. And lastly, I'll just say, again, reflexes and things of that nature. Sure, a person, Dr. Rubino has been doing this for 20 years, but understand that there is a subjective portion of that too, right? One person's 3+ out of 5 may be another person's 4+ out of 5. So there are inter-individual differences, even in the clinician who's doing who's performing the test.
So you brought up a point that this test is subjective. Would you agree that when a radiologist is reviewing scans or when you yourself are reviewing scans, you're doing it in an objective way without making some sort of criminal analysis or criminal finding?
Sure. And actually the first part of the radiologist report, and the same thing with the pathologist report, is going to be the description. You're going to just give an unbiased description of what exactly you are seeing. And then in the impression, you may give your impression as to what you think may be going on. But again, that's from a medical perspective. That's me letting the other clinicians know, hey, this underlying pathological process is probably going on, so you need to do additional tests. But we don't think about it from that perspective.
So when Dr. Rubino testified that he didn't want the radiologist to put his or her opinion of what they saw because they might be wrong, and he's looking at it from a crime point of view. What is that?
I would take affront to that as a pathologist if someone told me not to give a diagnosis on a slide I looked at or tissue I examined, because I had the requisite training to do that. I went to school and did many years learning how to properly interpret that particular test. Another clinician hasn't, and so they shouldn't make an opinion above a radiologist. They should use the radiologist as a consultant to help them guide their clinical decision making, but they don't have the capacity to make a better decision than a radiologist does. That's my clinical opinion.
Now, going back to the MoCA, I got sidetracked a little bit when we were talking about subjective versus objective opinions. But would you agree that the MoCA is simply just a screening device?
Yes.
And so it's not actually considered a diagnostic.
It's one of the many tools that you would use in formulating a clinical picture.
Now, would you agree that a lot of different testing that a physician might perform or a psychologist might perform, that there are certain standards or certain requirements in order to perform that test?
Yeah, and every test that we do, yeah.
And what is the purpose of being properly certified to administer a test?
Well, it's reliability, number one. I mean, you want to make sure that you are appropriately administering the correct test in its correct form, so the answers that you elicit can be, actually examined, right, and utilized. And then you need to have some sort of inter-test reliability that your test is being performed the same way somebody else would be performing the test. Therefore, you can compare your answers or your results to somebody else. That's the only way you can truthfully arrive at a diagnosis that can then be, approached with treatment.
So would you agree that in order to administer a test based on testing requirements and testing standards, that person should be administered and how to give that test?
They should be, yeah.
Now, Dr. Rubino testified about essentially his opinion was based on the MOCA failure in conjunction with the MRI. Again, did you see anything when he says in conjunction with the MRI? Was there anything significant about the MRI that would suggest?
Several things I'll point out. I mean, I know he saw the MRI findings and he made the assumption that there was atrophy of the frontal lobes as well as the anterior temporal lobes, which I did not see any evidence thereof. Furthermore, the radiologist didn't see any evidence thereof. And he made the assessment that that was due to a history of trauma or chronic traumatic injury. But looking at those brain scans, I can clearly see that there is no evidence that I can find of traumatic or the patterns that one would expect to see in chronic traumatic brain injury. Furthermore, he goes on to talk about the hippocampus and the amygdala, which those being in the limbic center were somewhat atrophic and therefore can be used to explain perhaps a person's impulsivity. But I did not see any changes there in the amygdala or hippocampus to support that suggestion. Going on even to the cranial nerve exams, I know he had mentioned the the jerk nystagmus, the horizontal jerk nystagmus, as well as the cogwheel rigidity. I think he had looked at or said earlier that was somehow supported in the MRI, but we're talking about brainstem function here, specifically nigrostriatal extrapyramidal motor system, which he said, sometimes we see in Parkinsonism, and that's true. That's more ventral midbrain, and we saw the picture of the midbrain in there. And that's not something that I would see specifically in trauma. In other words, if forces are directed towards the brainstem, I'm not going to only see injury to the midbrain, I'm going to see injury as well as to the pons and medulla, which are structures that are continuous with that. I'm also going to see it in the white matter structures that are communicating with that structure, and we see no evidence thereof. If you do see extrapyramidal motor system defects, I could argue more importantly that it may be very well related to hypoxia or even drug use because certainly increased dopamine signaling in that part of the brain we know is associated with toxicity. Dopamine itself can be toxic. Dopamine, the metabolism of dopamine by our brain produces semiquinone radicals. It produces oxidative stress, leads to damage to that part of the brain. More importantly, hypoxia can as well. We know people who survive cyanide poisoning have Parkinsonism-type behavioral characteristics afterwards. And that's, again, because that region is more susceptible to hypoxia, more importantly, reperfusion. So let's say if you had an episode where you stopped breathing or were on drugs, let's say, opiates and breathing very slowly and then suddenly restored function, that reperfusion there could produce injury to that brain region. And that would be more consistent with the findings on cranial nerve exam than trauma, because I don't see any other associated findings or even imaging findings that would lead me to believe trauma caused that.
So as far as the brain scans, they're not consistent with that finding?
Yes, that's correct.
And I know you already talked about reviewing that CT scan from 2023. Defense referred to that incident as head trauma, but was there in fact any evidence of head trauma?
He was, no. And so certainly from an acute perspective, no evidence of trauma to either the head, the skull, the brain's coverings of the brain, and certainly did not see features that would make one think or suggest that chronic brain trauma was present.
Okay. And again, atrophy would have been reported on that CT scan had it been observed?
Yes, especially, because of the presentation of the patient at that point in time. You're trying to figure out, what's causing this patient's underlying condition. If there was a period of hypoxia related to, let's say, drug usage, that would be very important.
And was he in fact hospitalized for overdosing in the jail on fentanyl?
That is what I had read in the records.
Now, looking at that scan in 2023, would you have ordered any additional testing based on the radiologist's findings or based on your review?
Based on the radiologist findings, no. I would have looked elsewhere. In other words, I would have determined from that point in time there was nothing for me to be concerned at within the skull.
Now, another thing we heard about today is these self-reports that the defendant gave of being in car accidents and sports injuries. Did you find any actual evidence of those things or those incidents?
If there was a significant head injury, impact trauma, leading to either subarachnoid bleeding, which is bleeding on the thin coverings that are immediately surround our brain, and would make sense, right? If you're in a car accident, your head slams into, let's say, a windshield, your brain's also moving at that same speed and will slam into the skull. And that will can produce a bruise on the brain itself, so you would see hemorrhage in the brain tissue, but you may also see a tearing of the tissues that surround the brain, causing subarachnoid hemorrhage or subdural hemorrhage. I know it's a long explanation, but the point is that I saw no evidence there of that having happened.
Okay, and going back to those injuries, though, would you agree that those are all just self-reported, that you never saw any medical records or admissions records or anything to support that he had, in fact, been injured?
I would agree, because looking at the imaging, I wouldn't predict that there had been significant prior brain trauma.
So, based on all of your review of the records, based on the review of the scans, based on hearing and looking at Dr. Rubino's report, let me just quickly, before I actually ask you that final question, was Dr. Rubino's report, believing that he had traumatic brain injury, issued prior to any scans?
No. Not that I know. I mean, so his report, I only became aware of it yesterday, but his report, I believe, was based upon the results of scans that were performed prior. That's what you're asking. I'm not too sure. I'm sorry.
So when Dr. Rubino issued a report, I believe the state sent to you, and in that report he ordered new brain scans.
Okay, yeah.
So that report where he concluded he believed that there was some sort of brain trauma, was that conclusion then before we actually had those new scans?
I believe that conclusion was based upon his assessment of him physically.
So not including those scans. It
Not
was
including
just his
those scans, yeah.
physical assessment.
Yeah, that's my belief.
He believed it was
yeah.
traumatic brain injury, ordered the scans, and then that supported
Yes,
this.
because he had the history from the patient telling him about this history of trauma. He did the cognitive assessment as well as the assessment of motor skills, made the assumption that there was underlying brain trauma, and then had the scans performed.
Doctor, do you believe it's appropriate to make a diagnosis of traumatic brain injury before seeing any current scans?
Not a diagnosis. You keep it in what we have a differential diagnosis, or a working list of potential diagnoses based upon a person's history, as well as their presentation, their clinical presentation. And so you make a list of possible things that can go wrong. And obviously, brain injury is in one of those categories of dysfunction, right? You think about prior ischemic injury. Ischemic meaning lack of blood flow to an area of the brain. Not necessarily a stroke. A stroke could be one of the causes, but you think of mass lesions, you think of, for instance, prior drug overdoses or exposures, and you put trauma on that list, but you don't make a definitive diagnosis. You have a working list. Then you use your other modalities to sort of narrow that down. Hey, I'm looking at these imaging here. Do any of the patterns here suggest one of those diagnoses? And certainly the patterns that you normally expect to see in traumatic injury were not present in those images.
So now, final question. Based on Dr. Rubino's testimony here today, based on your review of the medical records, based on your review of the MRI and the CT scans, what is your ultimate opinion as far as whether the defendant suffers from any kind of brain trauma or brain injury?
I saw no evidence that there was any underlying structural abnormality to the brain that would be consistent with chronic brain trauma. So I would say no. To me, it looked like a structurally normal brain.
No further questions. The state tenders a witness.
All right.
Good morning. How are you?
As I recall from the last time you were here, you're the chief medical examiner, Panama City?
Tallahassee,
Tallahassee.
yeah, District 2.
Okay. And you're still doing that?
Yes.
How long have you been there?
I've been there since May 1st.
Your presentation today is seems to be based, tell me if I'm right or wrong, on Dr. Rubino saying, well, there is traumatic brain injury. Is that your conclusion?
No, I looked at the CAT scans and the MRI without forming, as I always do, before I form an opinion upon, even on my autopsy cases or cases that I perform a neuropathology examination on, I do not like looking at the history before I do an examination because I do not want to be biased as to what I am seeing. I then go back and I look at the actual history or what we think may have happened in a person's past to see if I'm seeing any features that would agree with that. But in this particular case, no. I looked at the brain scans and looked at the brain scans just like I would look at an actual brain, and I made my diagnoses and compared them to what Dr. Rubino had said, and then looked back to see if I could figure out what he was referring or how he arose at those conclusions, and I didn't agree with those.
You didn't agree that there was the atrophy?
That's true. Yes, because again, atrophy doesn't occur in isolation, right? So atrophy has to happen for a reason.
Just what is atrophy?
Sure. Atrophy just generally refers to shrinkage, right? So loss of normal size. When we're talking about the brain, atrophy refers to loss of substance or brain tissue, in particular the neurons that make up that's the sort of the most important unit of the brain are the neurons and then the associated nerve fibers.
As you get older, doesn't your brain shrink naturally?
Not naturally, pathologically, but yes, it will atrophy, yeah.
All right. Well, on those images that you just looked at, in the frontal region, there are dark areas. Is that part of the atrophy?
No, you're looking at different T1 and T2 images. So dark, normally fat lights up when you go to T2. Water and fat will light up, and so you're looking at just the different types of MRI images. But there wasn't any abnormal white matter pattern that I can see. But more importantly, it isn't just so. If you have a dark area, you have to have a corresponding. Which, if you're saying that a dark area of the brain is due to loss of tissue, well, then you also have change in the tissue around it, right? So, in other words, tissue gets lost, infarct, trauma, what have you. There's hemorrhage, inflammation, and then you have scarring. And so you have a change in the morphology of the tissue around it. The tissue in this brain was normal. There was no atrophy, abnormal change in the gyri, so there was nothing that I could see that I would attribute to atrophy.
I think that image was taken last week, August 21st, I think. If Mr. Wilson had suffered traumatic brain injury, and I'm not sure how you level that.
Sure.
But, I mean, not everything is a complete blow to the brain. But if he did suffer that, and it could regrow, regenerate,
Well,
fix itself?
the brain doesn't regrow. The brain has a very limited capacity to regrow, at least with regards to the nerve cells or the neurons, right? So ultimately, the central nervous system, when we have injury or loss of nerve cells, you have replacement of that by scar tissue, and the scar tissue in the brain is called gliosis, or the astrocytes fill in that void. That tissue never regenerates. There are areas of the brain that have stem cells, but they really do not contribute to reorganization of the brain following injury. So when you have injury and loss of tissue, it's essentially gone forever.
But that doesn't necessarily mean that there's a impairment. I mean, the brain works around the injury, right?
Impairment with regards to what? Are you saying to when the original injury occurs?
Correct.
So when you have a concussive injury, let's say, really is injury to the white matter of the brain, right? And when you have a concussion, you don't have to have cell death or loss of those neurons, right? You can have a disruption of the cytoskeletal elements on the inside of those nerve fibers. And that disruption of the normal cytoskeletal elements causes abnormal flux of ions, swelling of that nerve fiber, and therefore the normal electrical signal that would move from the top of the cell to the bottom of the cell is disrupted, right, if not impeded. And so while that process is repairing, it's not regenerating, it's just slowly going back to normal. And that can take weeks to months. The cell then is returned to its normal state, but the cell itself doesn't die. So therefore, you're not actually losing and regenerating a cell. You're just allowing for the normal repair process to occur. You're allowing for the inflammation to subside. Now, if the injury is severe enough, you would lose cell tissue, and that's irreversibly lost. It really comes down to the amount and level of tissue. Let's say he did have trauma to his brain and he did have concussive injury with loss of tissue. It's not significant enough for me or anyone really to see here on this imaging technique. You know, you're probably going to have to look even microscopically or use really, really sensitive techniques. But even so, if it's severe enough to produce abnormal function, you should see it on the imaging.
The claims of pre-existing injury, they were quite some time ago.
Sure.
Okay. Now, what happens if you have pre-existing injury and you add FLACA to the mix? Let me ask you, what is FLACA?
Well, it's that very similar to the sort of novel psychoactive stimulants. It's sort of, they have somewhat stimulatory as well as hallucinogenic effects in the brain.
And or cocaine, let's say. What effect would those have if you've got pre-existing, minor, not necessarily traumatic, but...
Well, it's very hard to predict because it really depends upon what structures of the brain are injured and where there's minor trauma. Because cocaine, is going to cause a massive alteration in brain dopamine, right? And so that's primarily going to affect, your with respect to cocaine, limbic system, perhaps.
Excuse me, I apologize. What's limbic system?
Oh, sure. Those are the structures of our brain that include the hippocampus as well as the amygdala, the mesiotemporal cortex, structures of the brain that are interconnected there, and they really are involved in our emotions, our emotional learning, as well as short-term memory formation. Those structures are involved in taking our environment and sending on short-term memory to become long-term memory. But to answer your question about drugs and their effects, drugs will have adverse effects on a normal brain, right? It really comes down to not so much brain structure as it works at the molecular level, right? People that have our drug metabolism enzymes play a role. Our drug receptors and how well that drug can bind to a receptor and activate that nerve. So it goes much deeper than that. But drugs themselves can have, you can't predict how prior brain trauma would affect the effects of a drug. It really comes down to what areas of the brain are injured.
So in other words, nobody knows what the effect of
Yeah,
drugs
it would, yes, it would really be on an individual basis, and yeah, and there's so many variables there. It'd be hard for me to answer that.
Thank you. May I have one moment, Judge?
You may.
I assume some of this, but I'll ask you.
Sure.
Have you ever met Mr. Wilson
No, I
other
have
than in
not.
court?
No, I have not.
Have you conducted any testing on Mr. Wilson?
No, I have not.
Did you review, other than what you've testified to from Dr. Rubino, did you review testimony of any other professional witnesses?
I did not.
You reviewed the test results, or at least the imaging from Dr. Rubino?
I reviewed the images that he reviewed also, as well as the medical records that had the radiologist review. I heard and I read what Dr. Rubino said about it from his deposition.
Okay. Did you ever review the MRI of Mr. Wilson?
I reviewed, yeah, all of those images.
Okay. And there were what, 8 images?
There were several imaging studies that were performed. Yeah, I can't recall the exact number, but yeah.
Did you prepare, from what you reviewed, did you prepare any images, presentation to support your testimony?
No, I just my knowledge and my knowledge of the literature and my experience.
Are you aware of any psychiatric or neuropsychological diagnoses in this case?
In this particular case, no, I did not review those reports.
And you're not qualified to controvert diagnosis by either Dr. Rubino or the radiologist?
Well, when it comes down to looking at brain structure, absolutely I can. That's my job.
Okay. Now, if Mr. Wilson is impulsive based on the addition of cocaine or flocka to the mix, or he's unable to recognize implications from his conduct, are you saying that, in your opinion, the MRI does not support that, the MRI images?
Well, so take a step back. How cocaine or any of those, psychoactive drugs can affect a person. Certainly we know that they can phenocopy all of the positive and negative symptoms that we see in schizophrenia, as well as the psychoses that we see in bipolar disorder. Within that realm of behavioral activity, one would expect to see agitation, impulsivity, and other abnormal behaviors while under the influence of those drugs. That those do not correlate with having to have abnormal imaging findings. That can occur in a structurally normal brain. It has to do with the effects of the drug interacting with our brain receptors.
So you can have
So you can have a normal brain and still exhibit those behaviors. And I didn't see any changes on his brain that would be anything that would deviate significantly from normal.
Thank you, Judge. Thank you.
Thank you very much.
All right. Anything else? All right, sir, you can sit down.
Thank you.
Any other witnesses from the state? No. All right. So any other witnesses or any other evidence of any mitigating circumstances under Spencer that the defense would like to have the court consider at this
No,
time?
I just have some argument with it.
Okay.
You want to do that now, or you want to do that at sentencing?
If you want to present argument now, and I'll give you an opportunity to address the court again at sentencing, you can do both, or choose whichever you would like.
I'd rather do it at sentencing because of something that my client said when you inquired of him. I need to talk to him.
Okay. Very well, so you'd rather wait until this afternoon?
I would.
Okay. All right, then. At this time, then, we'll be in recess until 2 o'clock this afternoon, and see you then.
Hey guys, I do not have any idea what's taken so long this morning because there are 4 court cases we're watching and all of them are on break at the same time. I'm sorry about that. I feel like if I start Judge Boyd or something that they'll come back. So I guess we'll just continue to wait. I'm sorry. Even Young Thug's on break. Ugh. Well, remember, if you have something you guys want to watch on intermissions, go ahead and shoot me a DM or put it in the comments.
For non-speculative.
She 2 days earlier, February 14th, with the understanding that she
So that's on February 14th for all that. Where I stumble or where I pause is, do we have an evidentiary foundation for a non-speculative inference that she actually gave Eric Richins a controlled substance on February 14th?
So we do, Your Honor. Let's
Or attempted to do so?
sure. Let's kind of focus in then on February 14th, with the understanding that she 2 days earlier, the probable cause understanding that she 2 days earlier purchased fentanyl from
Sure.
Ms. Lauber.
Got it.
Okay. So her conduct on Valentine's Day helps establish that she, in fact, provided the fentanyl to Eric Richins. And so her conduct that day starts early in the morning when she purchased a sandwich from the Mirror Lake Diner.
Well, we know she makes a purchase from the Mirror Lake Diner, right?
Yes.
We don't know that it's a sandwich based upon admissible evidence.
Sir, we do.
Tell me how.
The invoice from the Mirror Lake Diner entered into evidence as Exhibit 66. Shows a, I think,
Yeah, bagel sandwich.
Okay,
Got
bagel
it.
sandwich. And Your Honor, we also know from the defendant's own words that in her text message with her best friend, she admits to purchasing a sandwich that day.
Remind me, which exhibit is that? We're gonna need to talk about that.
I'm
in some
gonna need
detail.
need
Yeah.
some help on that.
I know what you refer to, but I just need to look at it with you.
Yeah, I might have it in my notes, Your Honor. If not, we're working on that
Okay.
on the side.
But keep going, we can go chronologically.
So we know from the invoice and from her text message that she purchased a sandwich that morning from the Mirror Lake Diner. We also have, as the court's seen, all that confirms an order. The invoice corroborates that the phone call is related to the order in Exhibit 66. So she purchases the sandwich from the Mirror Lake Diner. I think it's something like a 9:07 pickup is what the invoice shows. We then know at 9:43, the defendant, it's Exhibit 8, Your Honor, is a text message with her best friend.
Okay.
We then know at 9:43, she text messages her paramour that she's on her way. And at 9:49, she sends him a navigation screenshot that shows her kind of leaving the Camas area with an arrival time at some unknown destination approximately an hour from then. We also know, based on her text activity with her paramour, that they were essentially together all day. And we know that because, as the court can see, they text frequently throughout the day. But throughout that day, they weren't texting with each other. And I think the reasonable inference is they were not texting with each other because they were together. While the defendant is an hour or so away from Eric Richens with her paramour, Eric Richens has some medical event strong enough that he texts the defendant and says he's considering going to the hospital. We have that text exchange in evidence. Feeling sick enough to go to a hospital, and then sleeping in the garage, which he also texts, for about 2 hours, which is consistent with no activity on his phone and associated devices. All of that is consistent with the reaction to
I've read it, but I can't remember the number. The number for the 1102 from the person that lays that foundation regarding a reaction, if any.
Yes, so that's the toxicologist, Matt Slauson.
Okay, thank you. Keep going.
Your Honor, also in evidence is literature from the Mayo Clinic, which lays a similar foundation. Okay, so we now have, right, in the chronology of Valentine's Day 2022, the defendant and her paramour an hour or more away. Eric Richens sick enough that he's considering going to the hospital and is inactive for 2 hours. All of that consistent with fentanyl poisoning. And then at that point, the defendant's own words are kind of important here because he texts her, right, of his illness, of considering going to the hospital. And what she says is chilling. She says, take a nap. And then she doesn't check on him for 2 hours. She doesn't come home. She doesn't text. She doesn't call. She doesn't check on him. Their next communication is 2 hours later when Eric Richens checks in with the defendant. Notably, throughout the day, Valentine's Day, and thereafter, the defendant's reaction to Valentine's Day events is consistent with a consciousness of guilt. She had texted on February 11th and 12th significantly with her drug dealer during a time frame that corresponds with the drug dealer's purchase of fentanyl at the Maverick and the Draper.
Right.
Those texts are deleted from her phone. She texted with the drug dealer 30 times, about 30 times with Mr. Kotradimos' testimony. On Valentine's Day, and those texts are deleted. There is no good reason the defendant is spending Valentine's Day with her paramour and texting her drug dealer 30 times. Eric Richens texted the defendant a photo while he was texting her about feeling ill and considering going to the hospital. That photo is deleted from the defendant's phone and also from Eric Richens' phone. That is in the moment consciousness of guilt. The next day,
Forgive me, I don't recall testimony from Mr. Kotradimos or any documentary evidence about when those images were deleted. Now, I acknowledge they were deleted sometimes after they were created, but
very young.
okay. Okay.
The next day, after Valentine's Day, February the 15th, 2022, the defendant lamented to her paramour, if he could just go away, life would be so perfect. And then 2 weeks later, she assured her paramour, life is going to be different, I promise. Hang in there until Friday. On Friday, Eric Richens was dead. We've referenced Exhibit 8, the text messages that the defendant sent to her best friend.
I don't think that's 8. I think Celebrite is 8. Can you give me that number? It's 8.
Well, Your Honor, it would be found in the Celebrite extraction.
Oh, my apologies. Okay.
So,
It's not like a screenshot, it looks
Oh,
like
okay.
a download.
Let's get there together. I need the exact language of that. It would be. Okay, got it. So this is, we got to be specific about this, a June 18, 2022 communication, correct?
yes, Your Honor, it's
Okay.
June 18, 2022. I can give the court some context, which the court's already familiar with on the timing. The timing relates to the same allegation kind of is wrapped up in the attempted homicide charge that was made in the civil litigation. And timing would suggest, I think it is reasonable to infer that they were discussing this text is a discussion of the Valentine's Day 2022 incident as put forth publicly in the civil filing.
I have some questions about this when you're done going through the evidence.
Okay.
I also have questions about the February 15 text messages, so just put 2 pins in those. I'm not questioning the existence. I know those exist.
No, sure. So that glance was to get a copy of whatever the
Okay.
February 15th text was.
Well, it's if you would just go away, ... and then
Yeah.
I promise we'll be together on Friday or words to that effect.
Yeah, yes, Your Honor.
Okay.
We can discuss those kind of texts when we're both looking at them.
Okay.
The text to her best friend regarding Valentine's Day. The defendant says, it was Valentine's Day and Eric and I were both working from home that day. We know that to be false. We know that to be false from her text messages with Eric himself. We know that to be false from her text messages with her paramour. We know that to be false from the navigation screenshot. Continuing with the text, she says, he, meaning Eric, never broke out in hives or used an EpiPen. She did not know that. She was not with him. The court can reasonably infer that the opposite is true. She is lying about being with him. She is lying about him not breaking out in hives. She is lying about him not using an EpiPen. Because she knows those facts are indeed true and indeed inculpatory. So do you want to discuss those texts, or should I continue on with further answering your question is how the homicide charge kind of relates directly to the attempted homicide charge?
Well, let's pause here for a second.
Yes, sir.
We also skipped over or didn't mention in that recitation. Remind me of the date where she asks CL for something stronger.
So, Your Honor, that I don't know that I know a precise date. It's somewhere around February the 25th.
It's here somewhere. I think it was 12 days later, right? Okay.
And Your Honor, the court raises an important point, right? I said at the outset that the best evidence of the attempted homicide by poisoning is the actual homicide by poisoning 17 days later. And the defendant learned from the attempt and applied it to the homicide. And we see that with what the court just raised. She wanted something stronger. She learned that whatever she used on Valentine's Day wasn't strong enough, which is why she went back and asked for something stronger. But she had a similar MO, right? You know, her MO is to go to the drug dealer, procure fentanyl, and 2 or 3 days later, 4 days later, administer fentanyl. That is the same. The drug is the same. The drug dealer is the same. The timing is the same. But she learned. She learned she needed something stronger. She also learned how to administer it. She learned that putting it in a sandwich where Eric Richens could take a bite, feel the effects, set the sandwich down, was not the proper way to administer a fatal dose of fentanyl. Instead, she administered it with a lemon shot, where Eric Richens would throw it back all at once. She says that in her journal article, her journal note at Exhibit 49. And she learns that it takes a truckload of fentanyl to kill him. She learns that one bite in a sandwich isn't enough. It has to be stronger. It has to be administered in once, and it has to be a lot. And that's why Eric Richton's toxicology shows 5 times the lethal amount in his blood and 20,000 nanograms per milliliter remaining in his gastric fluid. The attempt and the homicide are connected in MO and lessons learned.
If we view, let's imagine for a moment that everything through February 15, well, February 26 stays the same. Imagine Eric Richards is still alive. The text message on June 18 gets sent. I imagine you tell me we'd still have probable cause of attempted murder.
We would, Your Honor, and I guess that goes back right to the standard of this hearing. You know, all reasonable inferences go to the state.
And I hear you telling me it's a non-speculative inference that you tried to poison him because we have her admitting that she ordered lunch from Miro at the diner. We have him having a significant enough event that he contemplates going to the hospital. We have text messages on February 15 that draw reasonable inference that she wanted it dead. We have her out looking for something stronger when he did not die on February 14. We have a financial motive. We have the medical foundation. The difficulty is, right, and maybe this just highlights the low threshold that is the probable cause determination. And I imagine this is what Ms. Nestor or Ms. Lewis is going to tell me, is this turns just about every possession charge into an attempted murder charge if the spouse has some medical event around the same time. But here you'd say...
And the spouse dies 17 days later under very, very similar circumstances, same MO, connection between the two.
And is it 404 that lets me connect the dots here?
I don't even think the court has to go to 404. I think the court can connect. I mean, certainly it's probative. So, yeah, certainly it's relevant. I guess the court could connect the dots through probative, but there's no doubt, especially, you know, returning to the fact that this is a domestic violence case. The court sees the consistency in the domestic violence defendant's conduct throughout. The motive is super strong. I mean, I know we've kind of agreed that the motive is present in both circumstances, but
it's equally present. It's separated by merely 3 weeks.
correct.
Yeah.
It's equally as strong. Now, Your Honor, the court raised, you know, that this isn't speculative, and it's not. And Schmidt kind of talks to the notion, the point, right, that the court's job here is not to sift through the evidence and find the most reasonable explanation, just to make sure that the state's record, the most reasonable inferences, just to make sure, rather, that the state's inference is reasonable. And we leave the most reasonable inference question to the jury.
Okay. All right, so if you've got probable cause for count 2, you've got it for count 4.
Yes, sir, I think two goes out, or 4 goes out, 2 goes.
Right. I think I understand the state's position here. You will, of course, get the last word on counts, on all counts, but certainly counts 2 and 4. I have some questions regarding some of the financial counts.
Yes.
Bear with me for a moment. All right, count 8 for insurance fraud. What is the conduct that forms the basis of that count? Count 7, the $100,000 true stage policy, I'm following the state's argument. I'm not sure what count 8 refers to.
Yes, Your Honor, and in the statute under count 8, the insurance fraud statute has different non-exclusive, or I guess different exclusive theories of presenting an insurance fraud claim.
Certainly.
And then count 8 is kind of the broadest claim. It's the scheme claim.
Well, for count 7, right, it's either it could be the forged signature, it could be the false representations regarding how Eric got the fentanyl in him. Either one of those, I think, would get you there. Let's just say it's the false statements regarding the fentanyl.
Sure.
You have a forgery count
Sure.
regarding the false signature, I think, in either, bear with me, 9 or 10, or maybe 11. Candidly, I think 11 is the forged signature on the $100,000 policy.
Sure.
So
That relates to the claim, right? Count 7 is a false claim
right.
on an insurance policy. Count 8 is a scheme devised to get the money falsely from an insurance company.
But
Can or cannot involve a claim.
fair enough, but is it I acknowledge that we don't need to get into merger today, but
Sure.
is it the forged signature on the $100,000 true stage?
Sure, it's the signed application on January 28th and 29th. It starts with the application
Okay.
for the policy that issued on February 4th,
Right.
10 days before the attempted homicide,
Okay.
a month before the homicide. It starts with that signed kind of application that the court will recall there was no way for the insurance company to contact Eric Richards. Rather, they could only contact the defendant, right? The defendant used her business P.O. box. The defendant used her email. The defendant provided an improper phone number.
Okay.
And so submitting that application begins the scheme.
Got it.
And the scheme continues through the false claim for the money. And the evidence of that is the claim log we submitted into evidence as Exhibit 67. But different than the false claim where the mens rea and the actus rea is just submitting a false claim with the intent to get paid on it. The scheme is much more sweeping. The scheme in count 8 is I'm going to submit a false application for insurance on Eric Richards' life. I'm going to then cause his death and then seek money.
Understood. All right, so with respect to the 3 forgery counts, 11 is allegations regarding Eric Richards' signature on the application for the $100,000 true stage policy.
Correct, Your Honor. That's the policy of Exhibit 17.
What is 9 and 10?
9 is the fraudulent bank statement that the defendant provided to Ironbridge, and 10 is the similarly fraudulent statement that the defendant presented to Boomerang. That's the cut. Those are the cut and paste job
Got it.
statements.
And so the forgery count of 9 is related to the mortgage fraud count that is in 5, right? And then the forgery count in 10 is related to the mortgage fraud count in 6.
Correct.
Got it. Okay. Thank you. Anything else you want to put on the record at this time?
No, Your Honor, I'll be back.
Very good. Ms. Lewis, how are you?
I'm fine, thank you. I'm going to address really just counts 1 and 3 and a little bit of 4. And then Ms. Nestor is going to address count 2
Okay.
and the remaining counts.
Tell me where you see the gap on count 1.
All right, well, here's where I see the gap on count 1. So I understand that there was a finding made at the detention hearing. And I understand that the court can consider the transcripts from that hearing. However, I think we're in a kind of an interesting situation because the burden of proof has to be at the preliminary hearing, and the court does need to make a new finding at this hearing. And I actually think, interestingly, that this is a situation where additional information that came in makes it less likely and makes it more difficult for the state to establish a reasonable belief as to the first element of aggravated murder, that she actually intended and knowingly killed Mr. Richards. Because what we learned yesterday is we have now the affidavit, or the 1102, from Ms. Lauder. What that really tells the court is only one thing, is that she believes she gave fentanyl to Ms. Richards. She doesn't know what she gave Ms. Richards. Whatever she gave Ms. Richards has been through at least 3 people before it came to Ms. Richards. Ms. Lauder got it from somebody, Mr. Crozier, who got it from somebody else that we don't know who that other person is. None of these people manufactured it. None of these people tested it. So we don't know what was given to Ms. Richards.
I don't disagree that we don't know, but knowing is not the legal standard that I'm required to apply today. So tell me why Ms. Lauder's 1102 is insufficient to support a reasonable belief in the parlance of preliminary examination law that the stuff that she provided was fentanyl.
Let's look at the distribution counts and examine that.
Yeah, we can do it. All right, go ahead.
So looking at the distribution, and then I'll backtrack a little. So Detective O'Driscoll said that he had no way of knowing, that he did not know what was in the pills.
He just knows that they are blues or greens, which, given his experience with, he didn't say narcotics, but with controlled substances, is consistent with street fentanyl.
Blues, he said.
Okay, there you go.
Anyway, I was trying to remember if this was in the record or not before I said it out loud. So that's what was my pause there. But I have never seen a distribution case where we don't have anything that was distributed.
You mean a preliminary hearing or a trial? Two very different universes.
Well, personally, neither. Okay? Personally, I have not seen it either place. But I don't think just an individual who's a drug addict saying, I thought I gave her fentanyl, I mean...
Doesn't that form the reasonable belief, though? I mean, by all accounts, Carter Lauber knows the difference between a controlled substance and not.
Well, that's not in her affidavit. How do we know that? How do we know that she knows the difference?
With respect, she's in drug court and she faces controlled substance convictions. So apparently she has some experience with it.
But Detective O'Driscoll testified that she said initially, and she said it in more than once, that she knew nothing about fentanyl. She didn't deal fentanyl. It's not her drug. And he said that.
These are great trial arguments, but I question whether this would be sufficient to... These concerns are sufficient to rule that there's only a speculative basis rather than a reasonable basis.
And I understand.
There was provision of a controlled substance.
I mean, I understand your position and where you're headed with this, but I do think we want to, for the record especially, Detective O'Driscoll testified that he cannot say with any certainty
Sure.
what happened to those pills. We have no knowledge, no testimony, no evidence, even if those pills were fentanyl. What happened to them after February 25th? I mean, the third ones were allegedly received after
Right.
Mr. Richard's death, which is interesting in terms of what these pills were actually for. And I think, and again, maybe a trial argument, it's interesting that if that was the purpose of these pills, that they were still being handed out afterwards. But he said he could not testify what happened to those pills. He cannot testify what was in those pills. And he does not know how, if those pills were given to Mr. Richards, and if they were, how they were given, who gave them, did he take them himself? There isn't any evidence as to that. And I understand, the position and the very low standard we're looking at here. I get it. But that would be...
To be clear, the court's position is based on an application of the standard, not because I have an
I
independent belief
understand.
of what did or
And
didn't
I didn't
happen.
mean to imply that
Right.
it was your personal belief. I understand the standard.
Right.
And your application of the standard. Our position is still that there needs to be something more when you look at everything that's been presented as evidence in this case up to this point. And particularly on the distribution count, I think it's...
3 or 4.
Well, to both, but there's additional, of course, problems with the February 14th
Right.
distribution.
With if there is evidence sufficient to support a reasonable belief that Carter Richards put some drugs in a drink and handed it to Eric Richards, there's probable cause for the count 3, right?
Yes,
Okay. All right.
you're right. But I think I've made my argument on that. And I just don't think that anything that happened from any of the other witnesses, of course, goes any further to show anything about count 1. It goes to the motive, which is an element of count 1, especially the Ms. Carrington's testimony. I understand that. But nothing that they said, I think, goes to intentionally or knowingly administering the drugs.
Well, the motive would provide some foundation for intentionally or knowingly. Let me put it differently. If there was no motive, the inference would be harder to draw, correct?
Yeah, you're
Okay.
I think that covers what I have in our record on that. I don't know if you have any other questions, but Ms. Nestor will talk about counts 2, and then that, of course, relates directly to count 4. And she'll address the financial ones.
Okay. I think I understand.
I'm talking about before they get to you. I haven't got to that part yet. You're jumping ahead of me.
Okay.
But what brings them to you is the people sitting right here. And it's their opinions, it's their beliefs. They're not a grand jury, they're prosecutors, they do their best. So what we have created to protect clients from that awesome power that sits at that table is this process of a gatekeeping. That instead of society to come together and close doors and hear the evidence and decide whether there's enough to put someone through this, they bring it to you. You're the gatekeeper. And this preliminary hearing is a critical right that every single individual who they decide to write a charge against has. And when we come before you, we recognize that it's a low standard. We recognize that probable cause means that. It just means enough to charge you. It doesn't mean enough to convict you. It doesn't mean enough to determine you committed a crime. It's enough to charge you. But that charging decision does matter. And it's going to have a huge, huge impact on the way this case plays out, on the evidence that is brought before the jury, on who will be witnesses, determining what charges get past this gate, you the gatekeeper. So we believe very, very, very strongly that the charge of attempted murder has not met the lowest standard even of probable cause. And that as rare as it is for a judge to say there's not even enough to charge here, it is anticipated that that will happen on occasion, which is why you do thousands of these, right? Because every once in a while, they don't get up to that level. And And we think in this case they haven't done it, and we'd like to tell you why. So thank you for indulging me that.
I agree with everything you said about the law.
Okay.
What is the essential element of count 2 that you believe the state has either shown no evidence of or insufficient evidence to draw a reasonable inference regarding?
Causation, 100% causation. So, in order for them to establish an attempted murder,
Right.
they have to show that Ms. Richens took some act that caused someone to be in danger of death, right? She had to have caused something that put them at risk, right? Whether they actually died, obviously it's attempt, right? So, I think it's critical that you understand the timeline of that day. And I want to walk it through, and I know it may take us a couple of minutes, but I think it shows so clearly that they cannot make the connection. And it's indisputable evidence that's in the Celebrate that has been downloaded off their phones. There's no debate about what happened on those phones, okay? So, in Exhibit 6, there are substances of text between Eric and Corey that say exactly their communications that day. I want to go back to the very beginning, which is the receipt, which is Exhibit 66 from the Mirror Lake Diner. It shows that Corey's credit card swiped at 9:07 a.m. and that she ordered a bagel breakfast sandwich and an omelet. There is a statement under the sandwich that it's over hard, which means it's an egg sandwich. There's an egg in that breakfast sandwich, and I think that's important because I don't know about you, but I'm not eating an egg sandwich 2 to 3 hours after it's brought to me. You eat it quick or you don't eat it. So she brings an egg sandwich home at 9:07. This actually doesn't come in, but I think the court could take judicial notice because of the address on Ms. Carrington's exhibit about the Willow Creek home where they resided. It's about 5 minutes away from this cafe, and I don't think the DA will, or the county attorney will dispute that.
Nothing in Camas is very far away.
Nothing in Camas is very far away. So it's about a 5-minute drive from the cafe to their home. So best case scenario of her credit cards being swiped at 9:07, she's getting home around 9:15 in that area. Maybe.
Is there any evidence that she actually went home?
Correct.
Well, I'm asking.
There is. On her phone, the printout of her phone shows her returning back to. Well, actually, they've introduced that exhibit that they blew up that showed that she was on her way to the house, and that's from her home.
Okay.
So she was at home. So there's a period of time where she's at home between 9:15 and 9:41 a.m. with eggs to eat. Now, it is a fair assumption that when you bring eggs home, you eat them quickly. So it is perfectly possible, and just as inferential, that she could have had breakfast with her husband that morning together. And let me tell you why I believe that that's proven in the state's own case. Because at no point in any conversations, any texts between Corey and Eric, does he ever tell her that he's feeling sick until he tells her at 11:40 something that if I'm still feeling this bad, I'm going to go to the hospital. So it sounds very much that they've already discussed that he doesn't feel well, right? So it is perfectly consistent with Corey Richens' statement to her friend, they ate breakfast together, which would make it pretty hard to poison someone when they're sitting there and you're handing them their food and watching you hand them their food. So then you have Eric between 10:21 and 12:06, and these are reflected in exhibit number 38, which shows the locations of calls made by Eric.
Would you pause for a second?
Yes.
Is there a statement that they ate breakfast together?
They just talked about her telling her friend lying that they were together when they ate.
So, I just want to make sure I'm not missing anything that you're seeing. quote, forgive me folks, I didn't even make him a fucking sandwich, those fucking idiots. It was Valentine's Day, and Eric and I both were working from home that day, and I ordered lunch from Mirror Lake Diner.
Well, that was months later, and she hadn't seen the time. She hadn't
Okay.
been exposed to any of the
Hey, folks, I need you to take a deep
She-
is there any evidence that she has a backward-looking statement saying, I ordered breakfast?
Well, that's the only statement that we're aware of.
Okay.
But at that point, she hadn't seen the time. So she's remembering if it was breakfast, lunch, whatever. I mean, that was months later.
All right.
But she admits she got it at Mirror Lake. She admits they ate it together. She mixed up the time of breakfast and lunch. I mean, there's no debate that she was not there at lunchtime. That didn't happen. So,
Right,
so that's clearly a mistake. So she leaves the house at 9:41 and is gone for the rest of the day. Eric drives to multiple other locations after she leaves.
Do we know, help me out, do we know that? Or
Yes.
was he doing the estimating from home? This was unclear to me from the testimony.
So in the Celebrate exhibit that is Eric's phone, it shows where he's making calls from.
Okay.
And so he makes calls from, I think he goes to it looks like the Smith's grocery store, the Walmart. He goes and runs some errands. He's
Right.
making business calls ever since Corey left, the whole time. After he's eaten the egg sandwich, he's driving around, he's making calls. Then he texts Corey at 11:27 and talks to her about some soccer fees that the boys owe. And then says a few minutes later, so between 11:27, he's talking about soccer.
Sorry about that. I paused it because Wade Wilson is back. So I'm going to go ahead and finish his sentencing. And I just paused exactly where we were with Corey's hearing. All right, here we go. Let's see if anybody can help him save himself from the DP. Who knows?
And as per the sidebar, I know Mr. Wilson didn't approach, but waiving his ability to be up here at the sidebar. And I'll just say what was said, that basically this morning we had a Spencer hearing. At the end of the Spencer hearing, defense counsel indicated they may have further argument and wanted to speak with Mr. Wilson regarding any other potential testimony. We recessed until 2 o'clock this afternoon. And so the court came back in to see if there was any further evidence or testimony, which appears there's not. And if there was any further argument regarding sentencing. Subsequent to that, I will take another recess, and then we'll come back for the court to issue a sentencing order at that time. So that's procedurally where we are.
Yes, sir.
Okay. All right, so is there any further argument then?
Yeah, do you want to get voting?
Yes.
Judge, briefly, you've heard all of the evidence, the testimony in the case. On behalf of myself, Mr. Hollander, Ms. Perez, Mr. Wilson, we want to thank you for your consideration of Mr. Wilson's sentence in this case. We understand that when a jurist takes the bench, we hope you don't have to make a decision like this. But we know that Your Honor has paid close attention. You've considered the law, you've considered the facts, the evidence, and you're going to render the decision that you think is just. Obviously, it's either sentence is a terrible sentence. The sentence of death is worse in that if there is a mistake along the way and we can't correct that mistake, we can't correct the sentence after it's imposed. We'd ask that the court consider the 3 statutory mitigators: the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of the law was substantially impaired. Obviously, you've heard testimony that he consumed quantity of controlled substances. He described it to the officers, said it basically made him almost insane. Defendant requires specialized treatment for mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. We don't know what kind of treatment that's going to be on death row. We know that he needs treatment. There's testimony to the fact that he's been on treatment. He's been on the same treatment throughout his stay in the Department of Corrections and in the Lee County Jail. He needs that medication. He needs that treatment. Defendant cooperated with the state to resolve the current offense or any other offenses. I'm sure the court recalls that Mr. Wilson provided a statement to law enforcement. At the time he provided the statement, he was not aware that they had located the second victim. He was doing that in an effort to assist the victim's family. They had already located the second victim, but he didn't know that. He provided them with details that, but for his statement, they would never have known. We have non-statutory mitigating circumstances. Defendant was born to drug-addicted teenage parents. The defendant's biological mother suffered mental illness. Defendant's mental illness presented at age 12 and was precipitated by puberty and substance abuse. Defendant was diagnosed bipolar disorder and I call it schizophrenia. It's a little bit different diagnosis. Defendant is loved by his adoptive parents, Candy and Steve Wilson, who has provided a statement to the court. Defendant is loved by his sister, which was reflected in the statement read to the jury. Defendant was profoundly affected by being abandoned by his biological parents. He's been a loving son to his adoptive parents, as reflected in the statement read earlier today. I remind the court that the jury's recommendation was 9-3 for one victim and 10-2 for the other. Under their previous statute, that would have required this court sentence my client to life. Likewise, I would remind the court that Mr. Wilson has been waiting trial for a long time. The unfortunate death of his previous counsel prolonged the litigation and impacted Mr. Wilson greatly. I point out to the court, lastly, obviously the court has received, and I know that you haven't read them because I have received notification from your office that these letters have been received by your office, but I know that the court would not read an ex parte communication, that the letters have been sent back to us, but obviously there are people that have been pleading for Mr. Wilson's life and for the court's mercy. There are some 40,000 people that have signed petitions to that effect. We'd ask the court to take into consideration that death is permanent. Death is different. And we're asking the court to impose 2 life sentences for Mr. Wilson.
Steve?
Good afternoon, Your Honor.
Good afternoon.
I'd like to point out, and I agree with defense counsel, that death is in fact permanent. Steve was 35 years old. Diane Ruiz was 43 years old. Both of their deaths were permanent. Back in June, when this court heard the facts and circumstances of this particular case surrounding the deaths of Ms. Melton and Ms. Ruiz, this court should have learned that this case was nothing more than power, control, and violence that led to murder. Mr. Wilson's decisions were not only pitiless and consciencelessness, but they amounted to tragically reducing Ms. Melton as well as Ms. Ruiz to nothing more than memories and photographs to not only their families, but also to their friends. The only reason why that happened was because they both encountered Mr. Wilson. The state, back in July, went ahead and prepared a sentencing memorandum for the court to consider. The reason why the state did that, Judge, was because the state wanted the court to be aware and point out specifically the facts and circumstances supporting the aggravating circumstances and factors that the jury considered in this particular case, and that the jury specifically found proven beyond and to the exclusion of every reasonable doubt. Specifically, the jury is the one that found that Mr. Wilson was previously or contemporaneously convicted of another capital felony or of a felony involving the use or threat of violence to the person. That particular fact, an aggravating factor, was established throughout the course of this trial by virtue of the verdict that was rendered by this jury when they found Mr. Wilson guilty of both counts of first-degree felony murder and first-degree premeditated murder. Secondly, Judge, the jury found beyond to the exclusion of every reasonable doubt that the capital felony was committed by a person previously convicted of a felony and under a sentence of imprisonment or placed on community control or on felony probation. Once again, this court, as well as this jury, received testimony, not only by virtue of receiving certified court roll prints, a certified copy of conviction as business records, but also received the testimony from our crime scene tech who conducted the fingerprint analysis and determined that Mr. Wilson was in fact one and the same of the individuals who was convicted of two felonies, that being trafficking in stolen property and false information to a pawnbroker on the 18th of September of 2019. That was less than a month before these murders occurred. That was established beyond and to the exclusion of every reasonable doubt, and the jury concurred unanimously on both of those. Capital felony was especially heinous, atrocious, and cruel. Judge, this particular factor screams for justice. The homicides by which Ms. Melton and Ms. Ruiz died at the hands of Mr. Wilson sets this case apart from normal capital felonies because, once again, it's conscienceless and it's pitiless. And it's unnecessarily torturous to both Ms. Ruiz as it was to Ms. Melton. You heard about the fingernails being broken, the many bruises to their body, of the face, the swollen eyes, the contusions, the bruising all over the torso and arms, the hemorrhages on both sides of the neck, the scalp bruising, the contusions to the lungs, contusions to the liver, to the back of the bladder, to the colon. Her brain was swollen. That was just Ms. Melton. And then we have Ms. Ruiz. She had the fracture of the nasal bone, the laceration to her left breast, her bruising on both sides of her body, the bruising on the back of her left forearm and on the back of her left hand, the fracture of her fourth finger, the bruising on her right arm, the contusions on her upper back, the hyoid bone, the trachea cartilage being broken, the multiple rib fractures in the front and to the back. And then we have the hemorrhage on the back of her neck. And then you couple that with the fact that Mr. Wilson went ahead and placed his hands around the necks of both of these women and allowed their lives to slip through his fingers when both of them knew they were going to die. The jury found that particular factor, Judge, unanimously, as to both Miss Melton and Miss Ruiz, that it was heinous, atrocious, and cruel. He overpowered them, he controlled them, he silenced them by placing his hands around their neck. Judge, we submit to you that factor should be given extremely great weight. And lastly, Judge, the aggravating factor of it being cold, calculated, and premeditated. The jury found, beyond and to the exclusion of every reasonable doubt, unanimously, that this aggravating factor applied to Miss Diane Ruiz. That evidence that was presented, beyond and to the exclusion of every reasonable doubt, you heard and was corroborated by the evidence in this particular case, the statement that was given by Mr. Wilson himself. He asked her where the high school was and if she could show him. He said that once he got her into the car, they'd drive to the school. He was going to drop her off, but he knew in his mind he wasn't going to do it. He started choking her because she started to get out of the car. You could tell that she was getting scared. He saw the fear, and then when she would not die, he pushed her out of the car and repeatedly drove over her and then attempted to dispose of her body in an empty wooded lot. Judge, that is what is precisely the sort of heightened premeditation that's contemplated by that specific factor. And we would submit to you that that particular factor also carries great weight. The mitigation that defense counsel has presented to this court, we would argue, counts for little weight. Not only that, but it's contested, Judge. It's controverted. Everything defense counsel has presented on behalf of Mr. Wilson, whether it be head injury, whether it be psychological issues, whether it be, family matters, all of that has been controverted. It has not been substantiated. There was no history of brain injury. It's not documented in any of the medical records. You heard here today Dr. Rubino's testimony. You heard counter testimony from Dr. Coyne. All of his scans were normal. Neuroimaging studies, both pre and post-arrest, indicate normal brain scans, although he'd have you believe that he had injuries to his brain. That is not anywhere in the record. As much as he'd like for you to believe it to be so, it is not. The review of the incarceration medical records do not indicate any type of cognitive problems whatsoever, Judge. You heard testimony by Dr. Eisenstein. That was controverted by Dr. Herkoff. Dr. Eisenstein even went so far as to present evidence as related to the Dallas Kaplan, function system. He tested averagely, Judge. He wants to talk about references to his memory, talking about that he has issues with short-term memory. That's not true. He has an ability to recount events when he wants to. He has an ability to tell stories. He has an ability to make you believe something that isn't true. And interestingly enough, Judge, the neuropsychological testing results are not consistent with any type of neurocognitive disorder. Even Dr. Eisenstein's own tests established that the defendant's executive functioning, the frontal lobe capability to be within normal range. Judge, you haven't heard anything in this particular case as far as any sort of mitigation that would outweigh any of the aggravating factors in this particular case. The aggravating factors should be accorded such great weight, Judge, that they were proven beyond and to the exclusion of every reasonable doubt as to counts 1 and 4 in the indictment as specifically found by this jury. They, Judge, support and are sufficient to warrant a sentence of death. And they are not diminished by the mitigating circumstances and are sufficient to warrant the sentence of death. And as such, Judge, the state would respectfully request this court to recommend and impose the sentence of death upon Mr. Wilson, because not only is it deserved, but it's earned. Thank you.
Anything else? All right. So this will conclude the Spencer hearing unless there's any other testimony or evidence that either side would want to present, especially the defense. Procedurally, my understanding is that we would take a recess at this point and then come back, and at that point that the state would want to present victim impact testimony or no?
Your Honor, I've spoken with the victim's family, and they would like to rely on what was stated at the actual trial.
Okay, so then this would be the final opportunity for the defense to present any other mitigating circumstances for the court to consider prior to coming back and issuing a sentencing order. Is there anything else that you want to?
We have nothing else, Your Honor. Thank you.
All right. And Mr. Wilson, again, your opportunity, if you wish to address the court, you may. No one can force you to. No one can force you not to. Is there anything you would like to address with the court? Okay. Then we will be in recess. It's 2:20 now. I'm going to spend some time on the sentencing order. So we will come back here at 4 o'clock. And I'll present the sentencing order at that time. Oh, another question before we go. I apologize. Did you all receive the pre-sentence investigation report?
Yes, sir.
Okay. And for sentencing purposes, I know that there are other charges that the jury found the defendant guilty of. If you would prepare any statutorily mandated fines, fees, or costs that are associated with those charges, do you have that? If you don't, that's okay.
I can't recite those, Judge. That's not a problem. I do
Okay.
have a score sheet as it relates to those additional charges as well.
Very well. Have you shared that to the defense?
Yes, Judge, I have.
Any objection to that?
No, sir.
I'll accept that.
Thank you.
All right, if there's nothing else for the court to consider, then we will recess and I will prepare a sentencing order and come back here. Said what, 4 o'clock?
Thank you.
We'll be in recess.
Hi, Monica. I don't know what you guys think, but I don't know how they can have another question and not a verdict. This guy is so guilty.
Okay, the record reflects that the hearing is taking place outside the presence of the jury panel. I have attorneys on both sides. Mr. Tellis is present. I got a note from the jury. It's been marked as Court's Exhibit number 25. Has a few questions. It says, can we get another laptop to review the digital evidence? So I'm assuming they want a second one. And so, does this, we have it? Okay, so I'm assuming there's no objection to the court having the court officer take back a second laptop, okay? Then the next few questions are, the first one is, can we get the side-by-side walk comparison video from the closing statement? Obviously, the closing statement is not evidence. Then the next question is, could we get the exhibit number for the Jeff Gehrman news article videos about Mr. Tellis? I believe that's in evidence.
It is in evidence. It's the lowest number of flash drives I've seen.
I just want the parties to agree before I answer.
I'm not positive, but that's what I think it's on the lowest number. Courts and
Do you want to approach and look at the exhibit list?
She's going to say flash drive, Judge.
instruction number, what did I say?
33.
Okay, it should be instruction number 33, and then please
Please
refer
refer
to
to
instruction number 25.
Mark it.
Okay, if you want to approach and see it, and this is what I'll have the court officer sign it. And a copy of this will be marked as Court's Exhibit number 26 as well. And maybe stay close by.
Can I take that exhibit, Judge? Thank you.
Yes. Do we have the other laptop?
Do you want to sign one of these that I'm going to work?
Yeah. Do we have the other? That's
Yep,
the
I'll
laptop.
carry that back.
Okay.
He says, I'm gonna go lay down. If I don't feel better, I may go to the hospital.
Right.
And I must respectfully point out that when the prosecution talked about her saying, go take a nap, and how that was chilling, he pulled that completely out of context of the rest of what she said in that text.
Do you need me to come home?
Would you like me to come home? Jesus, is that bad? You know, she even at one point later in the day talks about, he says, I wish you were here, and she's like, I would cuddle you. So that is very misleading to pull that statement out, and I need to correct that for the record. But regardless now, he hasn't been in her presence for 2 hours. If he ate that sandwich, he ate it around 9:30, give or take, at the latest. So in that period of time, he's been running errands, doing business calls, texting Corey, very benign, normal day-to-day texts. Nothing about, I'm about to die, nothing like that. He takes a nap for 2 hours. Then he gets up. They text romantic texts, wish you were here, like to cuddle. That's at 1:43 when he just woke up. The same period of time well, I'm sorry, that's not before. I withdraw that. Continues to make work calls from 1:50 to 2:30. Goes to a soccer game with his kids from 3:52 to 6:11. Takes the boys to get some food. Leaves food for Corey in his truck as they go back to the game because Corey is running late. And that's the day. That's the day that they're now saying that you can infer she tried to murder her husband. There's no evidence he ever took a pill from her. There's no evidence that she ever, if she put fentanyl in his egg sandwich at 9:30 and he ate it, he would not be okay for 2 more hours. He would not be. And there's zero evidence. There's not one piece of evidence from Eric himself that he ever took anything from Corey that day, that he felt bad up until 11:33 is the first time he feels bad. Now, I think you asked a fascinating question when you asked the prosecutor, do I need to consider the death as support for probable cause of February 14th, looking backwards? And I think that's a really important inquiry, because obviously, if you look backwards, everything you're looking backwards at shades how you look at something that happened before. But if you look at that count in isolation, there is no evidence that supports an opportunity for her. There's no evidence to support that he took anything. There's no evidence to support that he had fentanyl, OxyContin. And as a matter of fact, he told, wait, I have to think if this is in.
Can I ask you some specific questions about
Yes.
this? So let's take it one piece at a time here in terms of events after February 14th.
Yes.
In your view, can the court consider Ms. Richens' text messages to Mr. Grossman on February 15th? Can I consider them at all?
Can you consider them? I mean, I think you can consider anything you want to consider in terms of.
Well, see, that's the question. The Utah Rules of Evidence say, no, there's all kinds of stuff you can't consider under any set of circumstances. And it's often a difficult slalom course to ski. We did some of this yesterday morning, trying to get a sense from the defense of whether or not the court can consider things like the text message, quote, if he would just go away, end quote. Or as evidence of an inference that she wanted him not around anymore.
But that could be divorce. That doesn't have to be death.
I understand, and we're not at trial, and I'm not a jury, and so I have to contend with black letter law. Let me just get this out. I really am genuinely interested in your response. I acknowledge there are multiple credible inferences that can be drawn from this evidence. Several of them innocent. But I'm not allowed to pick and choose. I am not allowed to weigh the relative reasonableness or credibility of the inferences. I'm required to draw all reasonable inferences in the state's favor, to view the evidence as a whole in the state's favor, and identify is there a reading of the evidence that supports a reasonable belief. And so when you say things like, look, this evidence, she went home, I imagine Mr. Bloodworth is fighting the urge to jump up and say, and that just shows she went home to give her the sandwich. That just shows he went home to give her the sandwich. She went home to give her the sandwich. And so the reason I ask about the stuff afterwards, the text messages, her statement regarding ordering them lunch, being home together.
So the text message certainly could be considered for the death, right? Because he's still alive.
Well, I got that.
February 15th.
But that's not my question.
Right? So how does the statement on the 15th relate to something that didn't happen? She's talking about it in the future, right? Like,
I guess the question is, if on February 15th she has a text message showing a desire to have him not around anymore, why can't I consider that for her mental state on the 14th?
she doesn't say he should be dead.
I know, but we're talking in terms of reasonable inferences here.
It's, you know, criminal defense lawyers look at these phones, and it's pretty terrifying to think that someone's going to go back and look at text that you wrote about your spouse, you know, years later, and put it all into a cone of literal death threats when you say, I wish he'd leave, he's getting on my nerves, I want him to leave the house, I'm going to leave him, I want to divorce him. Eric, they put in Eric's divorce meeting with his divorce lawyer. I mean, this was not a perfect couple. They didn't have a perfect relationship. But to take a context, one single text, and to say that that gives you a reasonable belief that she tried to kill him the day before, I don't see the connection at all.
Okay.
I don't. I don't think that is a connection.
So I hear you saying you can consider a judge, but it doesn't have any weight.
I don't think it does.
Okay. Same response regarding her June 18, 2022 text to her friend?
That's what we just said, where she has not seen yet the time, like she hadn't had an
Got it.
opportunity to review the timing. So if she mixed up lunch and breakfast, but everything else in there is consistent with what happened that day.
What about her text message on or about February 26th to Carmen Lauber saying I need something strong?
Again, that's after the 14th.
It's a backward-looking statement, though, or at least it's comparative.
Well, apparently she had recently apparently according to Ms. Lauber, she had just recently got something from her. So,
Right.
I mean, that could be not connected to the 14th at all.
Okay.
So,
Or more specifically, not necessarily referring to what she got on the 11th,
Right.
but could be from the 25th.
but I mean, you have a claim that Mr. Richards was poisoned on the 14th. There is no medical evidence. There is no connection. There is no causation. There is nothing but pure speculation that because they believe she tried to kill him and successfully killed him in March, that must mean she tried it before. That is not enough to reach a reasonable belief that someone, and that's the question you asked at the very beginning.
Right.
Just because, I mean, it's like a backwards acting in conformity argument.
Yes.
It's a backwards 404B evidence.
Well, this is my question.
Right.
Does that exist?
Which, by the way, 404B's whole purpose of existing in every state in America and in the federal system is exactly to avoid this kind of prejudicial leap of because somebody did something once, they must have done it again. That's the whole reason we have 404B, is to prevent that.
I acknowledge that. I imagine you would acknowledge as well the numerous exceptions and the lengthy or the deep body of case law regarding exceptions to the general bar to propensity evidence. And so here, when Mr. Bloodworth makes references to modus operandi, he's arguing to some of those exceptions.
Right. Well,
In your view, does 404B work backwards or does it only work prospectively?
it only works prospectively, in my opinion. But the analogy as to why this is such damaging and risky analysis can be found in that rule, baked into that rule that our legislatures and our Supreme Court recognize that that's very, very dangerous to base a prosecution on somebody, well, somebody used drugs once before in their life, they're probably guilty this time. That's the whole thing we're trying to avoid in our system, and that's the whole basis for their argument on the attempt. That's the entire basis, because they know they don't have proof. They don't have medical proof. They don't have. We heard testimony about allergies. We heard about all of that. So I mean, there's innocent explanations for everything that happened on the 14th. Every single thing. So that doesn't lead to a reasonable belief. They are 100% relying on an action and conformity argument.
I don't think we heard the admissible testimony of allergies, but I take your point.
I'm sorry. I'm trying really hard
That's okay.
to separate it in my brain.
I understand.
I actually think it's included in the, I believe it's included in some of the exhibits, but we'll just leave it alone just in case I'm wrong about that. I can check that while he's back up. But having said all of that, you know, the distribution charge that is connected to the attempt charge, if the attempt charge doesn't have probable cause, the distribution charge doesn't have probable cause.
I agree.
They both have to go.
May I ask you about the consciousness of guilt argument that the state makes?
Yes.
Which I understand to be my words, not the state's. Why is she lying in her text message to her best friend in June about what happened on the 14th?
I think the only thing she got wrong was breakfast and lunch.
Well, I think her location about her being home all day is one of the things they lean We were working from home that day, and
I mean, that's easily provable, so it's not like when she's talking to her friend, she's trying to remember the day back, a few months later. And she got part of it right, and part of it wrong, and I just don't know if it's just, how do we know that, what purpose would that be, how would that serve as a lie?
the argument is that she's hiding the fact that she was with another person besides her husband on that day.
Okay, that's a good reason to lie, because you're with your boyfriend, and you don't want to admit you're with your boyfriend.
Right.
That's not conscious of guilt of killing your husband. That's not wanting to tell people you were hanging out with your boyfriend.
Okay. That's one credible inference, right?
Yes.
All right. Would you say that it's not a credible inference that the reason she's lying to her friend is because she had the scheme to be not present when
She admitted she was present with him, and she was. She brought him breakfast.
Okay.
So that's true. That inculpates her more than exculpates her. That's the opposite of covering herself. She's putting herself in the house with him on the day that they're claiming he was attempted to be poisoned. It's a statement against interest,
Okay.
in my opinion. Okay. So I don't really need to argue the distribution. You get that. All right. So the only other things that we have on the fraud type arguments. I do think that the state never established jurisdiction or venue for any of those counts. I don't believe we've heard any proof about why this court has jurisdiction over these acts. They did not establish where they occurred.
Why isn't there a reasonable inference that Corey Richens was making these applications and forming these schemes from Summit County?
And they have to show that. You can't just out of whole cloth make that up. There's no evidence that occurred.
Well, the standard of proof is the same for every element of the crime, right?
But
So
there's
evidence
no
of
evidence that was submitted.
She lives here, her business was based here. I think there's a basis for reasonable belief that she was initiating these contacts, forming these schemes from Summit County.
Well, I just want to make the record.
Okay.
I don't believe they've established jurisdiction or venue on any of those counts. Furthermore, on the, I don't see why the two insurance fraud counts don't merge here.
Correct me if I'm wrong, I'm seeing several merger issues in this
Yes.
information, but merger is a fact issue that's handled after conviction. Am I right about that? Not at a preliminary hearing?
Not after conviction, before, you said after conviction, you meant after.
Is it before
charge.
submitting it to the jury or after?
Merger?
Yeah,
I always do it as a pretrial motion, but
okay.
I may be wrong, maybe too, you're wrong.
I don't think it gets considered though at a preliminary hearing as a matter of law.
Well, I think if you determine at a preliminary hearing that two counts are actually one act, that you cannot push forward one of them. Absolutely, I think you can do that.
Do you
But,
have a citation for that? I thought it was the opposite at a preliminary hearing.
well, I think you would just argue that they can't make two separate counts. So there's not sufficient reason to believe that a second crime was committed because it's all one. So that's your finding, that it's a reason. You can't reasonably believe the second crime was committed because it's just one crime. Because the scheme swallows the allegation of the filling out of the application. I mean, it swallows it. So,
I'll take a look at this.
yeah. And then I think on the rest, we would just submit on the other counts, Your Honor.
All right, so let's just be clear. To the extent that merger needs to be considered as part of the probable cause determination, that's going to mean that 1 and 3 merge, right?
Yes.
2 and 4 merge.
No, not 1 and 3. Attempted murder is on a separate day. It wouldn't.
1 and 3, 2 and 4.
I'm sorry, let me look at what 1 and 3 is. I'm getting my numbers mixed up.
So the distribution counts merge into the ag murder and ag attempt, right?
No, those would be two separate crimes.
Tell me why. You can't
Because
commit them without doing the distribution, right?
Right, I think they don't merge though, they're separate crimes. Like distribution is a separate offense than the attempted murder.
Okay,
So
so
they wouldn't
then why
merge.
isn't, on the one hand, forging a signature and on the other hand, making a false statement when trying to collect on the claim? Why aren't those two separate crimes? What is the merger
Because
you're
they're
arguing for?
the two insurance fraud charges, because that is the same offense. Insurance fraud is not two separate offenses. And what they did is they said she created a scheme to wrongfully get insurance fraud. And part of that scheme was she signed the application and they just charged insurance fraud twice. I'm not talking about the forgery, I'm talking about the two insurance fraud charges. I think
Okay.
they merged.
Alright,
And
and just to be clear, you think they merge because it is the same fruit of the criminal conduct? That is, there was only one policy.
right. That's correct.
Okay, I understand.
That's correct.
Thank you.
Thank you. Can I just have 1 minute before I sit?
Of course.
Just one more thing, Your Honors. And I guess maybe the last thing I would say too is there's so many reasons that Mr. Richens could have not felt well that day and taken a nap. And to get over the hump of saying you're going to stand trial for attempted aggravated murder, which is about the next to most serious charge you can ever be charged with, because he went to take a nap, is pushing it, Your Honor. We're just asking that the court exercise your gatekeeping function. Let's remove that from the confusion it will cause the jury, the prejudice it will cause the jury, the complete lack of foundation. We're asking that the court take the rarest of steps and say, this one will not go forward. And we submit on that.
Okay, I understand your position. Thank you. Mr. Blow.
Your Honor, real quick on just the merger issue, it's two different policies. Count 7 relates to the, I think, $250,000 two-stage policy.
Because?
Count 8, I think, relates to the $100,000 policy.
That is not the way it is charged. I think that is, you're going to need to amend the information if you want to do that. And frankly, I don't think there's any allegation of fraud, or there's any, tell me why there's any reasonable belief regarding fraud related to $250,000 policy.
Fraud in the claim, saying that I don't know why Eric Richens.
That's not what she said with respect to the $250,000 claim. That was only with respect to the $100,000 claim. It's two separate diaries. This is why I'm asking.
Your Honor, I think in,
They were paid out at different times.
sure, in the one diary, though, they discuss both policies.
I don't think that's true. You can show me, but I looked at them carefully yesterday. They
Well,
are
let me
separate
ask you this.
diaries regarding separate policies.
Let me ask you this, sir. Is this an issue you're considering, and so I can show it to you, but I don't know that it's
I understood you to be saying count 7 is based upon statements made during the process of collecting the proceeds in June. Count 8 is the scheme to get the policy with intent to kill Eric Richens to collect. Are you referring to the statement, Mr. Burmester, of no known drugs, occasional cannabis use?
No, that,
That came out of the medical records.
Your Honor, it's Exhibit 18, page 1. It's the last note.
I see what you're referring to. So this is 803. second. Let's get to the bottom of this. My apologies, I had it backwards. Okay, so, count 7, thank you for this clarification, is with respect to the $250,000 policy. Got it. Thank you for that clarification.
Your Honor, regarding the 404B discussion, the purpose of admitting the evidence is further to many of the exceptions, propensity, intent, preparation, lack of accident, nearly all of them. 404B just relates to whether or not the defendant acts in conformity with her character, whether that's prospectively or retrospectively is irrelevant. The most of the defense's argument against Binder or the attempted homicide count, as the court kind of noted, a lot of that goes to the jury. A lot of that was arguing countervailing evidence. As the court is well aware, the standard today is notwithstanding countervailing evidence, whether that's countervailing evidence of how quickly Richens eats his eggs, or whether he was shot beforehand or afterhand. It's countervailing evidence. It does not apply to the court's analysis today. Part of that countervailing evidence, I find it ironic that the counsel argued we hadn't heard one piece of evidence from Eric Richens. What questions does the court have?
I understand the state's position. I understand you to be saying conduct in March is evidence of other acts admissible to prove an MO. I understand the state's position.
And the lessons learned, I think, is very important.
Sure.
We've had some discussion with defense counsel also as it relates to the standards at issue for the probable cause determination. And I think the court has sufficient evidence when viewed in the light most favorable to the state, when giving the state all the reasonable inferences, notwithstanding the countervailing evidence, to find probable cause here even without the 404B part. The 404B part helps, certainly, but I don't even think it's necessary for the court to get to a probable cause determination. And, Schmidt, in discussing probable cause, references that probable cause in a preliminary hearing is the same as probable cause for an arrest warrant. And if the state were to set forth all the evidence it has, put, referenced in its brief, argued here today, and charge an attempted murder, and ask for an arrest warrant on the information.
Or a search warrant.
Or a search warrant.
Right.
And if the state submitted it to 100 judges in Utah, 100 of them would issue that warrant.
Check to speculation.
It's an argument. Overruled. I understand the state's point. Okay. It is 11:29. We're going to come back at 11:50. Oh, Ms. Nestor, my
Very
apologies.
quickly, I checked the ME report. It did reference the fact he was positive for COVID, but it
Okay.
did not talk about allergies in the ME report. That's where I thought it might be. But I'll keep looking and see if I can find it. But I do know that he did test positive for COVID.
Understood. Thank you. 11:50, court's in recess. Thank you.
Yeah. Right. I just wanted to get a better perspective. It's 7 years.
But Richard, do you have any more drives through Europe planned? No.
Not, at least not in the wild part of Europe.
You know, my heart was beating for you. It was like my mom and I, is he gonna make it?
1,500 miles.
I can't imagine driving 1,500
3
miles.
minutes of amazing, beautiful roads, and then backcountry, like the hill country with
But
18-wheelers.
But did you enjoy the 3 minutes?
Those 3 minutes were awesome. And there were toll roads, so I paid $10 or something. I was like, I'd gladly pay.
Were you expecting the 3 minutes to last longer than 3 minutes?
Or at least give a sign that says the roads are gonna end, be careful. It's like.
And then,
And the 18-wheelers come here.
oh my gosh, is it 2 lanes or no?
Barely 2 lanes. My little car, brand new with like 5 miles.
Did you get any rocks, dents or anything?
Well, I hit the bumper. So and it was, don't tell anybody, between you and me. It was a blue colored car,
Mhm.
and I walked into a drugstore and they had a rack of nail polish. And in my face was a blue nail polish, so I got the nail polish.
Please tell me after you did that, you remembered to put a clear coat on.
I sanded it down first with a nail file.
All right, and you gotta do, you can't just put the polish on and leave, you have to do a clear coat.
Yeah, so I put the clear polish
Okay,
and I turned it in, I washed the car, so.
and then you just walked away. What's the statute of limitations?
Probably however long my credit card lasts.
All right, who's here for Brenda Annette Ortiz Navarro? All right.
Your Honor, I have a student interpreter with me. May she observe?
Yes,
Thank you.
hello, hi, what's your name?
Leticia.
All right. Nice meeting you.
Nice
Come
meeting
down anytime.
Hasta enfrente.
So everyone, We're gonna speak at an even, slow pace. So the person who is shadowing the interpreter will think, oh my gosh, this is so easy. We're gonna talk in slow motion.
We'll strive to that end, Judge.
Right. Court is calling 2023 CR 1968, State of Texas versus Brenda Annette Ortiz Navarro. Could I have parties announced for the record?
Renee Munoz for the defense.
And are you Brenda Annette Ortiz Navarro?
Yes.
All right, so here's the thing. You gotta wait till the interpreter finishes before you speak. Otherwise, we don't need the interpreter. So do you want the interpreter?
Yes.
All right, so wait till he finishes interpreting. All right, and we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
And if you'll state your name?
Your Honor, the interpreter's name is Jorge Valle.
Right. All right, Ms. Navarro, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Yes.
All right. And Mr. Munoz, do you speak Spanish fluently?
I do speak Spanish, Judge, however, not fluently, more conversationally.
All right. Were you able to review the documents with her in Spanish?
I was, Judge, yes.
And do you believe she understands the documents?
I do, Your Honor.
All right, counsel, have you received all of the discovery? Did you review it with your client?
That is correct, Judge.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
All right, Ms. Ortiz Navarro, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No objection. from the defense.
All right, I'm just reviewing the paperwork to see if this is the way it should be, if it should be on this paperwork or not. Just one moment.
Yes, Judge. Theft 100 to 750 lesser.
All right, we're gonna go off the record for a moment. if you're having conversations with each other in the box, guess what? You're all at the Bear County Jail, so don't take any legal advice from either of you unless someone wants to know how long does it take to get picked up to go to prison. Usually you can depend on somebody who's at the jail. They know that answer. But as far as motions to suppress or anything else involving legal, they're in the same boat as you. Does everyone understand? All right. And I'm sorry, where did I leave off? Thank you. Thank you. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ortiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel?
Yes, Judge. In reference to that, I am aware that she is not a U.S. citizen. We did reach out to an immigration attorney within my office, and he did interview Ms. Navarro, and he did get information regarding her immigration status. He did prepare a memo referencing potential consequences under U.S. versus Padilla, Kentucky versus Padilla, actually, Judge. And I brought that information to the attention of the state and also my client, so that she was aware of potential consequences regarding a guilty plea or no contest plea with regard to this charge.
All right. And are you aware that by entering into a plea in this case, that one, theft is considered a crime of moral turpitude?
Yes.
And are you aware by entering a plea in this case, you will be deported?
Yes.
And did you have ample opportunities to speak to an immigration attorney?
Yes.
And do you understand that you will not be allowed to re-enter legally the United States?
Yes.
And do you understand you will be denied naturalization?
Yes.
Right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 179 days in the Bear County Jail. State is proceeding on the lesser included offense of theft, $100 to $750. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motion?
No, Judge.
Then to the lesser included offense of theft, $100 to $750. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No objection.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes.
Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We request that the court follow the negotiated plea bargain agreement. At the time of this offense, client was not working, was taking care of kids, and was not receiving any governmental assistance, largely due to her status here within the United States. The 179 days for immigration purposes is considered a petty theft offense, with hopefully not as many consequences as an original charge would have. So we're asking that the court please follow this agreement.
All right, the court is going to find you guilty. Court will sentence you to 179 days in the Bexar County Jail. You're credit for any time served, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you.
Your Honor,
Yes.
before concluding, it's under my understanding, my client has 402 days of credit. We wanted to ask if the court could announce that the judgment be satisfied with the 179 days.
I'll show that the judgment is satisfied.
Thank you, Your Honor.
You're welcome. All right, is there anything else?
Nothing further, Your Honor. Thank you so much.
All right, thank you.
Thank you, Your Honor.
All right, thank you. Oh, that should be gracias.
Gracias. Gracias.
De nada.
Sorry.
Louis, why you on us?
That's all I know.
You know what?
Guadalupe Roque.
established, 6 were given little weight. The totality of the mitigating circumstances indicates that the defendant suffers from drug use from a young age, along with undiagnosed and untreated mental health issues of some kind. He felt abandoned by his biological parents, but had a devoted adoptive family who raised him in a State's President, Defense Counsel, and the defendant are all present. We're here for sentencing. Was there anything else that the court needed to address prior to sentencing?
No.
All right. So I have considered all of the testimony and evidence, arguments of counsel, applicable case law, and statutes. I have prepared a written sentencing order, which I will file contemporaneously with the pronouncement of the sentence here today. I also have copies for the state and defense, which I'll hand out once I conclude. So in the state of Florida versus Wade Stephen Wilson, case number 19 CF 568, the court will read aloud the portion of the sentencing order related to the sentencing circumstances and proportionality. In evaluating the aggravating and mitigating factors, the court does not engage in a mere counting procedure, but instead makes a reasoned judgment based on the totality of the circumstances. In reaching this decision, the court is mindful that because death is a unique punishment in its finality, its application is reserved only for those cases where the most aggravating and least mitigating circumstances exist. The law never requires the imposition of a death sentence. In this case, the totality of the circumstances indicates the defendant, with premeditation, beat and strangled Christine Melton in her home before stealing her vehicle and driving to meet his girlfriend, Melissa Montanez. After Montanez refused to get into the car with him, the defendant battered her in broad daylight. The defendant told law enforcement, when Ms. Montanez managed to flee from the defendant, he fled the scene and drove back to Cape Coral, where he decided that he would murder another person. He saw Diane Ruiz walking to work and pulled over, pretending to ask for directions. She got into the car to provide directions, but the defendant strangled her when she tried to exit. He then drove to an empty lot, strangling her into unconsciousness at least one additional time on the way there. When she tried to flee from the car, he drove over her at least one time, inflicting mortal injuries to her spine, ribs, and neck. The evidence showed that both murders were heinous, atrocious, and cruel, and that the second murder was cold, calculated, and premeditated. The defendant inflicted serious physical and emotional pain to the victims. Moreover, the defendant committed the murders while on probation for prior felony convictions, and he committed 2 first-degree murders contemporaneously with each other and with grand theft of a motor vehicle, battery, and burglary of a dwelling. There were no statutory mitigating circumstances that were established, but the court considered the non-statutory mitigating circumstances presented by the defendant. Out of 13 enumerated non-statutory mitigating factors, the court found that 10 had been established. Out of those established, 6 were given little weight. The totality of the mitigating circumstances indicates that the defendant suffers from drug use from a young age, along with undiagnosed and untreated mental health issues of some kind. He felt abandoned by his biological parents, but had a devoted adoptive family who raised him in a supportive and loving environment. Defendant did not resist law enforcement when arrested and confessed fully to both murders. The court has further considered giving great weight to the advisory verdict of the jury, who recommended that the death penalty be imposed by a vote of 9-3 on count 1 for the murder of Christine Melton and a vote of 10-2 on count 4 for the murder of Diane Ruiz. The court recognizes that there is no mathematical formula for considering the aggravating and mitigating factors. It is not enough to weigh the number of aggravators against the number of mitigators. The court carefully considered the nature and quality of each aggravator and mitigator. Having reviewed all of the aggravating factors proven beyond a reasonable doubt and all of the mitigating circumstances reasonably established by the evidence, the court finds that the aggravating factors greatly outweigh mitigating circumstances. Given the facts of the case, nothing in defendant's background or mental state would suggest that a death sentence is inappropriate. This court's review of other reported capital cases has led the court to conclude that the death penalty is not disproportionate in this case. Under the totality of the circumstances and evidence, the court finds no basis to override the jury's verdict. The totality of the circumstances warrants that the defendant, Wade Stephen Wilson, be sentenced to death for each count of first-degree murder. Accordingly, it is ordered in the judge that the defendant, Wade Stephen Wilson, be sentenced as follows. Count 1, first-degree murder of Christine Melton. The defendant is hereby sentenced to death. Count 2, grand theft of a motor vehicle. The defendant is sentenced to 5 years imprisonment in the Florida Department of Corrections. Count 3, battery. The defendant is hereby sentenced to 364 days in the Lee County Jail. Count 4, first-degree murder of Diane Ruiz. The defendant is hereby sentenced to death. Count 5, the burglary of a dwelling. The defendant is hereby sentenced to 15 years imprisonment in the Florida Department of Corrections. Count 6, petty theft. The defendant is hereby sentenced to 364 days in Lee County Jail. The defendant is given credit for all time served on this case on all counts. All counts are to run concurrent with each other, meaning at the same time. All statutorily mandated fines, fees, and costs as announced on the record are imposed, and the defendant is committed to the custody of the Department of Corrections for execution of this sentence as provided by law. The defendant is hereby notified that these convictions and sentences are subject to automatic review by the Florida Supreme Court. If he cannot afford an attorney to represent him in any appeal, the court will appoint one for him. Are there any other matters to present to the court?
Briefly, Judge, the state would be seeking $17,500 cost of prosecution.
I'm sorry, how much?
$17,500, Judge.
All right. Any objection?
No, sir.
All right. That will be imposed then. Any other terms or conditions?
Absolutely, Judge. We just want to make sure that Mr. Wilson has absolutely no contact with the victim's family in this particular.
There'll be no contact ordered with any of the victim's family members and anything else.
All right, thank you.
All right.
Judge, I understand he has other cases pending here elsewhere. Mr. Wilson asked me to ask the court within whatever authority you have to get him to death row as soon as possible.
Okay. Well, in relation to those other cases, I know we have cases pending here in the circuit. Today is not the day to handle those. I would maybe put those, I could do it as early as September 16th. I believe that's Monday morning.
That's Malcolm's case, Judge.
Yes, Your Honor. Malcolm Dowling from Mr. Wade Wilson. September 16th would be fine, but.
Okay. Well, I think it'd be more appropriate to handle that at a different time. So let's do that September 16th then at 9 a.m. for the other cases, which are case numbers.
20 CF 16591 and 23 CF 15499.
Okay. And we have court on 16th, right?
Yes, Your Honor.
Okay.
Judge, if I may, he also has a VOP warrant out of Broward County, Palm Beach County. I'm going to get in touch with the authorities over there, but if need be, we'll ask the court to ROR him on that VOP warrant so he can be taken up to.
Well, it's not a motion in front of me today, but if you're certainly able to file whatever you want to file, and
Yes, sir.
I'll consider it.
Thank you.
All right. Anything else?
Not from the state, Judge.
All right, sir. Then, Mr. Wilson, you will be fingerprinted and remanded to the Sheriff's Department. You'll be held without bond and for transport to the Department of Corrections when it's appropriate. If nothing else, then we're adjourned. And I'll give you your copies. Original. Mr. Shirley or Mr. Hollander? Well, one for the state, one for the defense. Thank you.
can engage in cruel and unusual punishment unless it infringes upon the rights of a protected class. And that's just absolutely not correct, Your Honor. And
Okay, what specifically are you seeking from this motion?
what I'm seeking at this point, because again, really what they've done is, well, I guess we want to get into it. At this point, I am seeking to have the sheriff speak to the administration at the detention center to open a dialogue about moving me to an area that better suits my safety, while also, giving me an opportunity to engage in more research and also more recreation time. I was in that situation for about a couple weeks before an informant raided my personal papers, and there is again no reason to not have me in a situation like that. I've gone ahead and included in my reply proof that the move was not made for my safety. It was really made, it was a temporary situation, basically made permanent because I annoyed classification with my request for status. And the response in my reply demonstrates that, Your Honor. So again, all I'm asking at this point is an open dialogue so we can see about getting me moved to better accommodations.
Your Honor, I have not seen a reply.
Well, he filed a reply.
I was not served the reply.
It was served to everyone on electronic service, so I don't know.
I did not receive it. So I don't even know what his reply says at this point. However, Mr. Tellis is appropriately, first off, he totally misunderstands the argument that I made in my pleadings. I'm not going to go into it and prolong this because actually I did point out that the 14th Amendment applies. But regardless of that, he is appropriately housed according to what occurred in the jail. He doesn't have a right to a specific housing. He will be looked at to be rehoused as it's appropriate on a regular basis as every other inmate is. And if it's appropriate, he will be rehoused. But at this point, it is not appropriate. So he is where he needs to be. As to his access to all of the legal documents that he seeks, I'm sorry, he chose to represent himself, and as the saying goes, you made your bed, now you have to lay in it. The court went above and beyond of trying to explain to Mr. Tellis what it means to represent yourself, and he was fine with it. Ferretta is very, very clear, and the court went bent over backwards to make sure that Mr. Tellis understood all of the consequences of representing themselves. He said he's okay. He went through this. He doesn't get any special treatment for that, because otherwise we have 3,000 other inmates that would need to have that special treatment as well. It's just not possible. What he's experiencing is like everybody else. He's been treated like everybody else. This is just what it is to be incarcerated.
Your Honor, I think we might want to continue this so she can read the reply. I mean, it's just
I don't have any
taken.
problem.
I don't need to continue it.
Okay, all right, anything further?
Sheriff McMahill just.
I'm sorry.
Sheriff McMahill has absolutely misinterpreted all the case law, has basically got the material facts incorrect, and the reply shows again that Mr. McMahill or Sheriff McMahill's position is that his employees can engage in whatever cruel and unusual punishment they wish, and there's nothing that can be done about it. That is the position that was cited by that case law. What was said was only under the 14th Amendment can you exercise the equal protection clause. But that's not true. We're talking about the due process clause. That is what this motion is operating under, to basically protect my rights against cruel and unusual punishment. And so for Sheriff McMahill to say, well, you don't get it, you're being treated the same way. Sheriff McMahill does not actually respond to the fact that I've provided proof that my move to the 24-hour supervision or solitary with 1 hour out, which again, we're not getting 1 hour out, we're getting half an hour, that it's fine for them to do that. But again, the case law that I've shown they cited says that 14 hours is appropriate. When you talk about day room access, Sheriff Mayhill thought that saying 2 hours in an exercise yard meant 2 hours out of your cell for the entire week. No, Pierce v. Orange County said 2 hours for an outdoor recreation yard with equipment and 14 hours out of your cell for access to a day room. So, unfortunately, we're currently living in circumstances that may violate many people's 1983 rights. But for me, again, I'm in a situation where there are less restrictive means that have been proven to be appropriate for me. Once an informant who did not put me at risk for my own safety, but only again for risk of a setup. And again, my reply has the documentation on that. Only because of that reason was I moved, and the move was made permanent. So it was not to serve any legitimate government purpose. It really was, again, based on the other types of activities I've listed in my motion and the reply. Really, I guess, an undue punishment for being a pain. And so all I'm asking again is that we open a dialogue to see about other means for housing that are less restrictive. That's it.
Anything else? Okay, so this time the court's going to deny the motion. Obviously, you can speak to the jail and the people in the detention center about your classification, but the court is not going to tell the sheriff how to run his jail. We have one more thing, the standby counsel issue, and I'm assuming you still want standby counsel?
If Your Honor again is inclined to appoint.
Okay, before I do, I need you to raise your right hand to be sworn by the clerk. I'm going to have to ask you issues to determine whether you would qualify as an indigent person, so the court could appoint one. Raise your right hand.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your first and last name for the record.
Robert Tellis, ROBERT, TELLES.
And can you tell me what income you have, if any?
Right now, personally, I have no income.
Okay.
And I'm married, but again, I personally earn $0.
All right. Do you have any assets? Homes, bank accounts?
I currently co-own a home with my wife, and then there are 5 properties in Arkansas and Hot Springs that are up for sale to hopefully raise funds for council in the future. Right now, those homes are subject to a sizable mortgage, and only 3 of them are currently rented. Right now, the rents cover...
Let's start with, if you co-own a home, is that here in Clark County?
That is correct.
Okay. Do you know the value? I mean, approximately what the value is?
I'd say probably about $500,000.
Okay. And does it have a mortgage?
It does.
How much is the
About
mortgage?
$1,300.
I mean, like, total. The mortgage, 300, 100?
I couldn't tell you at this point, Your Honor. Maybe $200,000.
Okay. So there's about 300,000 in equity?
Right.
Okay. And then you indicated there are some properties in Arkansas?
Correct.
Well, they're like rental, like houses?
Right.
Okay. And there's 5?
Correct.
And you said how many are rented?
3 out of the 5, Your Honor.
Okay. So you get rental income?
Yes, and again, as I mentioned before, the rental income covers just about the mortgage and the repairs. So
Right.
there isn't any net income after that's covered.
Okay, so those 3 homes that are rented, how much rent do you get total?
They're probably about $2,800.
$2,800 total?
Total, correct. And again, like I said, you've got to factor in the mortgage and the maintenance as well. So that is not net income off of those properties, Your Honor.
All right, what are the mortgages on those properties?
It's one mortgage for all 5 properties, Your Honor.
How much is
And
it?
so the mortgage and the insurance together are
Okay, what's total mortgage? Is it 100,000?
about 320 or so.
Okay, 320,000, and it covers all 3 properties?
All 5 properties, Your Honor.
Oh, I'm sorry, all 5. All right, so the other two, what is, they're not rented, they're vacant?
That is correct, Judge.
And did you indicate, did you just say you're going to sell them, or do you have plans to sell them?
And they are currently listed for sale.
All five?
Correct.
Okay. How long have they been listed for sale?
I'd say for about 6 weeks now.
Okay. Have you had any offers?
There's been some interest, but no official offers, no.
Okay. And how much are they listed for, each one?
It's listed as a package, Your Honor.
All
Because,
five?
right.
So someone has to buy all 5 houses?
That's how I purchased them, and that is the only way to really break those free of that one mortgage, Your Honor.
Okay. So all 5 houses are on the market for how much?
For $519.